Good morning, everybody, and let me welcome all of you to the Subcommittee on Oversight and Investigation and tell you we appreciate your early attendance, and if possible, we'd like to start promptly at 10 o'clock. I'd also like to point out that Chairman Upton has indicated this will be a very active committee. It's a very important committee. I think most of us on both sides of the aisle realize that Congress, the House of Representatives, has a very important role as oversight of the executive branch. In this case, there's many areas that we can explore, both in a way that is substantive and at the same time, I think, in a bipartisan way, to have a better understanding of where there is error, where there is complement, in the long run to give full oversight to the executive branch according to the Constitution. So I welcome this opportunity as chairman of this very important committee, and I thank Mr. Upton, our chairman of the Energy and Commerce Committee, for this distinct honor to be able to be chairman. And of course, on the Democrat side, they've had some very illustrious people in the Oversight and Investigation chairman, including Mr. Dingell and Mr. Waxman and others. So I look forward to this opportunity for the next term, and I welcome from both sides of the aisle any comments or feedback. Let me open with a little bit of procedures. All members will have 5 days to make their opening statements part of the record by unanimous consent. Also, we've agreed under our procedures that there will be no opening statements except for the chairman and the vice chairman, Ms. DeGette, and then she will allot 5 minutes to her members for another additional 5, and I'll do the same on this side. So again, I'll do my 5 minutes. Ms. DeGette will do her 5 minutes. Then I have 5 minutes that I've allocated to members on this side, and then you'll have the same thing. With that, let me proceed to my opening statement. We convene this hearing of the Subcommittee on Oversight and Investigation today to gather information concerning the administration's views and plans for regulatory reform. Now, we can all agree that this is a critically important topic worthy of being the Energy and Commerce first hearing under the new majority leadership. Over the past 2 years, as the American public confronted the worst unemployment crisis in a generation, it simultaneously has faced an onslaught of federal regulations with more yet to come. While the growth of the regulatory state has been continuous concern over the past 2 decades, the pace in recent years has been breathtaking, given the nation's dire economic situation. According to the OMB data compiled by the Heritage Foundation, in the fiscal year 2009, which spanned both the Bush and Obama administrations, major rules added $13 billion in new costs to the economy. In fiscal year 2010 alone, federal agencies promulgated 43 major rules that imposed compliance costs estimated by the regulators themselves at almost $27 billion, the highest annual level since 1991. All we know, and we know agencies' estimates of costs may often be just the tip of the iceberg when it comes to the economic impact on jobs, competitiveness, and innovation. Now, along with all of these major rules come daunting levels of red tape, the cost of which cannot easily be counted. The Obama administration's regulatory agenda, released this past fall, identifies 4,225 rules under development. The EPA alone has finalized 928 regulations since the start of this administration, and it has also proposed a number of expensive and complex new rules affecting our energy system, our industrial and manufacturing infrastructure, and even the electric power we rely upon every day. On top of this, new rules related to the expansive new health care law and the financial service reforms are certainly looming on the horizon, with regulatory impacts on many different aspects of our lives, from our health to our wealth to the freedom to live our lives the way we want. The federal regulatory state continues to grow and intrude. Of course, many regulations derived from the laws Congress enacted are essential to protect the public health and welfare and ensure free markets. While appropriate implementation of these laws is essential for these purposes, appropriate consideration of the economic and employment impacts of the regulations is essential for protecting the nation's health and individual freedom. I am concerned that this balance has not properly been struck during the apparent rush to regulate over the past 2 years. Against this backdrop, we consider today the President's new executive order and initiatives relating to regulatory review and his stated focus on reducing the economic burdens of regulations and promoting job growth. Now, this focus is to be commended. We hope it will lead to meaningful results. And to this end, we seek to understand specifically how the administration performs its regulatory reviews and what changes we can expect that will reduce the regulatory burden, especially in the areas of this committee's jurisdiction. We will hear testimony and ask questions of a single witness today. Mr. Cass Sunstein, the current administrator of the Office of Information and Regulatory Affairs within OMB. Mr. Sunstein's office serves as the intersection of the administration's rulemaking review process. In some respects, his office serves or can serve as a regulatory traffic cop, carefully reviewing significant rules to ensure that they are consistent with the law, the President's policies and priorities, and that they receive appropriate review and analysis from other federal offices and agencies. He is especially qualified to explain the prospects and limits of the administration's regulatory reform plans. My colleagues, it is important that rhetoric is matched with measurable results and actions. For example, after the Bush administration took office in 2001, it made little change to the existing regulatory guidance, but it made extensive use of the available tools to return rules and ask questions and prompt additional review. It took an active role, sending 19 so-called return letters in the first 2 years of the administration. The present administration has not even sent one return letter. We will gather information about this today. We will also gather information to help us understand the substance of the plans for retrospective regulatory review called for by the President. We should seek to understand the limits of the review ordered by the President, rules issued by independent agencies like the FCC, the BCFP, CFTC, CPSC, FERC, FTC, SEC, FDIC, and the Federal Reserve, and the NRCC, among others, have apparently been placed beyond the purview of the President's review. And this will not be affected by this initiative. The information we gather today should help this committee's various oversight projects in the coming session of Congress. We have much ground to cover, so let me recognize, my pleasure, our new ranking member, Ms. DeGette.
Thank you very much, Mr. Chairman. I'm excited about the opportunity to serve in the 112th Congress as the ranking member of this esteemed committee. As you mentioned, Mr. Chairman, this is one of the most effective committees in the House, and in my 14 years on this subcommittee, it can also be one of the most bipartisan committees, and I look forward to working with you and my colleagues on both sides of the aisle, both on new initiatives and also to follow up on some of the key investigations that we were working on in the last session of Congress. I also want to thank my chairman, Mr. Waxman, and my chairman emeritus, Mr. Dingle, for their fine investigative work on this subcommittee over the years. Both Democrats and Republicans have supported laws to protect the health, environment, financial security, and safety of the American public. Today's hearing is about how to ensure that the regulatory system that implements these laws functions as effectively and efficiently as possible. This is a laudable goal that both sides of the aisle should support and which I personally support wholeheartedly. I was encouraged by the President's announcement last night in the State of the Union about his new initiative to streamline and modernize government, which is way overdue in many cases. The President's new executive order on improving regulation and regulatory review is an excellent starting point in this process. The order is based on such sound principles as the regulatory system must be based on the best available science, regulations protect public welfare while promoting economic growth and job creation should be retained, and the process must allow for public participation and the open exchange of ideas, and the process must take into account both costs and benefits. Consistent with this directive, the Obama administration has already identified several regulations that could be refined or cut, and I expect that we will hear from our witness today about additional areas where we can look at regulations. I commend the administration for this effort, and I hope that we can work together to support cost-effective implementation of the laws Congress has enacted to protect the American public's health, financial safety, and security, and their personal safety. These sensible safeguards are vitally important to the American people. We must recognize, however, that regulations per se are not the problem. The mantra that all regulations are inherently bad and kills jobs is wrong and dangerous. Just 2.5 years ago, for example, our financial system virtually collapsed. Following years of deregulatory efforts by Congress, the Securities and Exchange Commission and other federal financial regulators sat on the sidelines while flawed and unchecked financial practices robbed Americans of their retirement savings and caused our economy to nearly collapse. It wasn't regulations that caused the financial collapse and the deepest economic recession since the Great Depression. It was unbridled deregulation. For too long, big polluters have been allowed to dump toxic mercury into the air, resulting in birth defects and developmental problems for children in affected communities. Finally, after years of delay, the administration is taking action to rein in this toxic contamination, and we should all support these efforts. Again, it's not regulations that caused these problems, it's the lack of regulations. At the direction of the Supreme Court, the EPA has recently set standards to cut carbon pollution from cars and trucks. This regulation is a win-win. Not only does it cut pollution responsible for climate change, it saves 1.8 billion barrels of oil, making the nation more energy independent and secure, and saving American families money at the pump. Regulations to protect children from the health effects of tobacco and to prevent another salmonella outbreak in eggs or other threats to food safety are also important examples of where these problems have not been caused by an excess of regulations, but rather a lack of regulations. So when you examine the details of these and other safeguards, you find that there's a real need for government action. Now, I look forward to hearing from our witness today regarding the implementation of the Obama administration's executive order on improving regulations and the regulatory process. It's a common sense plan to cut outdated regulations and promote transparency. I also look forward to working with all members of this subcommittee to examine regulatory reform in a sensible way. Thank you, Mr. Chairman.
I thank the gentlelady. And now, according to our procedures, we have 5 minutes on this side, and they'll be allocated to Mr. Upton, the chairman, at 1 minute, Mr. Barton, 2, Mr. Burgess, 1, and Mr. Garner, 1. So the chairman, Mr. Upton, is recognized for 1 minute.
Well, thank you, Mr. Chairman, and I would ask unanimous consent that my full statement be made part of the record.
By unanimous consent.
Thank you for your very quick efforts to begin the work in this 112th Congress. We have a lot to accomplish over the next 2 years, and this subcommittee will certainly play a key role. Let me begin by welcoming our witness today, Mr. Cass Sunstein of the Office of Information and Regulatory Affairs. It is fitting that our first hearing is focused squarely on job creation and economic consequences of burdensome regulations that stifle investment and shift jobs overseas. Our majority has made it clear that jobs are priority number 1 in this Congress. We can create a climate of job growth by cutting spending, by limiting the size and scope of government. I've asked our committee members to track down burdensome regulations that choke investment and destroy jobs. We will identify these regulations, shine a light on them, and then seek repeal. I welcome the President's announcement that his administration plans to evaluate regulations to ensure that the benefits justify the costs and federal rules are tailored to impose the least burden on society. And I would ask that, again, the rest of my statement be made part of the record and yield back.
Gentleman yields back. The gentleman from Texas, recognized for 2 minutes.
Mr. Chairman, do you want to go back and forth?
No, we're going to take our full 5 minutes on this side, and then she's going to do her 5 minutes.
Okay, because okay. I ask unanimous consent that my entire statement be put in the record, Mr. Chairman.
Consent, Brandon.
Let me congratulate you on being the chairman of this subcommittee. It's one of the important, if not the most important subcommittee of what I consider to be the best committee in the House. In a previous majority, I was subcommittee chairman of this subcommittee for 4 years and enjoyed it immensely, and have worked with numerous other subcommittee chairmen in oversight. The importance of congressional oversight cannot be overstated. In my opinion, the last 2 years under Mr. Waxman, Subcommittee Chairman Stupak was not aggressive in subjecting the Obama administration to stringent oversight. I'm sure you, Mr. Chairman, are going to correct that. As Chairman Emeritus of this committee, I stand with Chairman Upton and yourself in support of immediate and ongoing oversight of the Obama administration and its practices and policies. Congressional oversight, if effective, leads to better functioning of government, one that protects the taxpayers by identifying excessive government spending, abusive regulatory regimes, and discovering ways to decrease spending and stimulate the economy. Today, we're going to discuss the President's executive order entitled Improving Regulation and Regulatory Review. The order instructs federal agencies to develop plans to ensure that past, present, and new regulations protect the public health, safety, and welfare and environment, while at the same time promoting economic growth. Who can be opposed to that, Mr. Chairman? However, having said that, in the last year alone, I have sent 3 letters calling attention to the lack of such analysis. I sent a letter to the White House concerning the impact of the Environmental Protection Agency's CO2 endangerment finding. I sent another letter to the EPA regarding the proposed economic impact of proposed ozone standards. And in this September, I sent a letter to Chairman Waxman asking that he schedule a hearing on the administration's decision-making and consideration of job impacts in connection with a major rulemaking and other regulatory initiatives that might adversely affect unemployment or employment in the United States. I see my time has expired, Mr. Chairman, so I'm going to yield back and ask that the rest of my statement be put in the record.
My consent will do. Thank the gentleman from Texas and recognize Dr. Burgess for 1 minute.
Thank you, Mr. Chairman. And I also want to welcome our witness here today, an important subject, improving the regulatory environment in our country. In fact, the President himself penned an op-ed in the Wall Street Journal on January 18, quoting from the President, "Over the past 2 years, the goal of my administration has been to strike the right balance, and today I'm signing an executive order that makes clear this is the operating principle of our government." It's too bad that we didn't have that principle 2 weeks prior, because in another editorial in the Wall Street Journal on January 4th, they talked about the EPA violating every tenet of administrative procedure to strip Texas of its authority to issue air permits that are necessary for large power and industrial plants. Going on, the best the EPA could offer up as a legal excuse for voiding Texas permitting authority last Thursday was that the EPA had erred in originally approving the state's implementation plan in 1992. The error that escaped the EPA's notice for 18 years was that the Texas plan did not address all pollutants. Back then, Texas hadn't complied with regulations that didn't exist and wouldn't exist for an additional 18 years. I'll yield back the balance of my time. Mr. Chairman, I would ask that both of these be made part of the record, these reprints from the Wall Street Journal.
I thank the gentleman and want to welcome 2 freshmen on the Oversight Investigation Committee, Morgan Griffith from Virginia and Corey Gardner from Colorado. And at this point, allow Mr. Gardner 1 minute.
But first of all, will the gentleman yield?
I would be glad to yield.
This is the first I can remember we've had 2 Coloradoans on this committee. And so I also want to welcome my neighbor to the north and also our other new freshmen, but particularly Corey.
Good. Mr. Gardner, you have 1 minute.
Thank you, Mr. Chairman, and thank you, Congresswoman DeGette. Thank you very much for the time to be here. Thank you to the witness. And I ask unanimous consent that my statement be entered in its entirety in the record.
By unanimous consent.
Thank you. Each day I'm in town, my staff or I sit down with about 5 businesses from Colorado. And every business that we meet with talks about the concern that they have, that this administration is regulating them out of jobs and out of business. And those aren't the only, and those that aren't already being regulated out of business are fearful that the proposed rules will put them on that path. We exist in an environment where government regulation is the answer to all of our problems. Congress can't get both the House and the Senate to pass a bill, so the administration does it. And they do it without having a process through Congress. The people speak through their representatives, and then the administration circumvents the people's representative. The process must be fixed, and it must be fixed here. The executive order is the administration's attempt to clean the regulatory house, so to speak. It's a directive to agencies that they must provide a cost-benefit analysis when justifying regulations and reduce the burdens on small businesses that are forced to comply. The question I have, though, is how do you define benefits and what constitutes a burden? The last 2 years have shown that the administration has a very different view of what benefits our economy and our working families. So today is the first step that we have to go back to our hardworking constituents with the answers that are presented to every member here. We need to examine these sweeping federal rule changes that have the potential to cripple various sectors of our economy and negatively affect every business. Thank you, and I hope we move away from when all else fails, regulate.
Thank you, gentlemen, and I recognize Mr. Gett.
Mr. Chairman, I'll recognize our ranking member of the full committee, Mr. Waxman, for our additional 5 minutes.
Mr. Chairman, I'm a strong opponent of unnecessary regulations. In my years of service on this committee and on the Oversight and Government Reform Committee, I led numerous oversight and legislative efforts to promote government efficiency and eradicate wasteful spending in programs. And in fact, in the 1990s, I served on the advisory committee for the corrections calendar set up by Speaker Newt Gingrich to identify outdated and pointless regulation so they could be quickly eliminated. I believe eliminating unnecessary government regulation is integral to ensuring effective government. But this is an area where it's easy to paint with too broad a brush. We need to remember that federal regulations also play a vital role in growing our economy and protecting our health and environment. That's why I'm concerned that much of the rhetoric we're hearing from the Republican side of the committee is a repeat of what happened the last time the Republicans took control of Congress. In 1995, the newly elected Republican majority conducted an all-out assault on regulations. They told us alarming anecdotes about the impact of senseless government regulation. We were told that the Consumer Product Safety Commission required holes in the bottom of buckets, and that OSHA killed the tooth fairy by preventing parents from taking home their children's baby teeth from the dentist's office. These stories share two traits. They sounded compelling, and they were simply not true. Now we're hearing repeated claims that regulations destroy jobs and stymie economic growth, and this is another myth. Consider the collapse of the financial markets in 2008. This meltdown on Wall Street threw our economy into the deepest recession since the 1930s. Millions of Americans lost their jobs, and it cost U.S. taxpayers billions of dollars to bail out AIG and Wall Street banks. The cause wasn't regulation. It was the absence of regulation. As Alan Greenspan testified before me and other members of the Oversight Committee, he said he made a mistake in promoting deregulation. He said he had found a flaw looking back over the situation in his free market ideology and was in a state of shocked disbelief. The Deepwater Horizon oil spill, which Chairman Stupak held hearings on in this subcommittee, as well as on food safety, as well as on automobile problems. Deepwater Horizon oil spill wreaked havoc on the economies of the Gulf states. It was caused by too little oversight and regulation, not too much. Members who are on this committee last Congress may remember our very first hearing. We brought in the CEOs from our nation's leading manufacturing and energy companies to testify. What they told us is that they needed Congress to pass comprehensive energy legislation so they could plan and invest for the future. Jim Rogers, CEO of Duke Energy, told us it's critical we know the rules of the road of climate change as soon as possible to make sure that we are making the right investments. Regulatory uncertainty is postponing investments and is postponing the creation of jobs from apprentices to engineers to PhDs. Jeffrey Immelt, Chairman and CEO of General Electric, who last week was asked by President Obama to lead the Council on Jobs and Competitiveness, told us, quote, certainty in the investment world is critical to success, and what we lack today is certainty. I'm a capitalist, pure, plain, and simple, and I just want the system we have today not to be untenable over the long term, insofar as the science is compelling on global warming, end quote. What these CEOs were telling us is that they needed more energy and carbon regulation, not less, so they would know the rules and plan and invest for the future. Subcommittee Ranking Member DeGette and I circulated a memorandum to our Democratic members that provides more detail about these examples and others. And Mr. Chairman, I ask unanimous consent that this memorandum be included in the record of today's hearing.
Granted.
Thank you. As we commence this new Congress, let's put aside the false and hyperbolic claims about regulations killing jobs. By all means, let's prune unnecessary regulations where we find them, but let's also not hesitate to regulate where needed to protect our economy and our children's future. There's no doubt that anybody would understand if you don't regulate to protect the environment, it's going to be at a disadvantage for a company to put in pollution controls if their competitors don't do the same thing. Regulations can make the market work better for everybody, at the same time protecting the public interest. Yield back my time.
I thank the distinguished member, and I ask unanimous consent that the written opening statements of all members who so desire be introduced into the record. Without objection, the documents will be entered into the record. Also, I ask unanimous consent that the contents of the document binder be introduced into the record. Without objection, the documents will be entered. Now we get to our witness, and let me welcome the administrator, Cass Sunstein, to our witness stand. I thought before we move forward I'd tell you a little bit brief background. I know oftentimes we have the witnesses and we don't know a lot about them, but I thought it'd be very illustrative for all of us to hear a brief summary of his resume. Before he became administrator, Mr. Sunstein was a Felix Frankfurter Professor of Law at Harvard Law School. He graduated in 1975 from Harvard College and 1978 from Harvard Law School. After graduation, he clerked for Justice Benjamin Kaplan of the Massachusetts Supreme Judicial Court and Justice Thurgood Marshall of the United States Supreme Court. And then he worked as an attorney advisor in the Office of the Legal Counsel of the U.S. Department of Justice. He was a faculty member at the University of Chicago Law School from 1991 to 2008. A specialist in administrative law, regulatory policy, and behavioral economics. He's the author of many articles and books. And so, Mr. Sunstein, I welcome you to the subcommittee's hearing. As you know, the testimony that you're about to give is subject to Title 18, Section 1001 of the United States Code. When holding an investigative hearing, this committee has a practice of taking testimony under oath. Do you have any objection to testifying under oath?
None at all, Mr. Chairman.
All right. The chair then advises you that under the rules of the House and the rules of the committee, you are entitled to be advised by counsel. Do you desire to be advised by counsel during your testimony today?
I do not.
In that case, if you would please rise and raise your right hand. Swear you in. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth? So help you God. Thank you. We welcome your 5-minute opening statement.
Thank you, Mr. Chairman. Thank you, Mr. Chairman. There are several other Mr. Chairmen. Thanks to all of you. I'm grateful and greatly honored to have the opportunity to appear today to discuss our new executive order. It has a new number, 13563, on improving regulation and regulatory review, and also our new memorandum from the President on small business and job creation. And I'll have a few words to say about that memorandum in a moment. The President has made clear that these documents are meant to create foundations for a regulatory system that protects public health and welfare while promoting economic growth, innovation, a key word in his State of the Union address, competitiveness, and job creation, as several of you have just emphasized. The executive order and the presidential memorandum require a number of concrete steps to achieve that overriding goal. By way of background, let me briefly note that since 1993, the process of regulatory review has operated under Executive Order 12866 from President Clinton, which builds very directly on an executive order issued by President Reagan in 1981 called Executive Order 12291. The Clinton executive order sets out a number of principles and requirements that were in operation both under President Clinton and President Bush. Among other things, it calls for careful consideration of costs and benefits, for tailoring regulations to impose the least burden on society, and for selecting the approach that maximizes net benefits. It also calls for a process of interagency review coordinated by the Office of Information and Regulatory Affairs. That process has been in place for nearly 30 years. The new Executive Order 13563 has 6 provisions that are designed to supplement and improve the process. First, it reaffirms the basic principles and structures of Executive Order 12866. In doing so, it emphasizes a point to which several of you have just pointed, the need for predictability and certainty. That's right out front in the new executive order. It also emphasizes the importance of using the least burdensome tools for achieving regulatory ends. That's a quotation. It emphasizes, finally, what hadn't been in its predecessor executive orders, the need to, quote, measure and seek to improve the actual results of regulatory requirements. That's the beginning. Second, the new executive order calls for public participation. It tries to bring rulemaking into the 21st century by requiring use of the internet to promote an open exchange of ideas and perspectives. It also directs agencies to act before they commence rulemaking to seek the views who are likely to be affected, including those who would be burdened by regulatory requirements. Public participation is front and center. Third, and a point that has received considerable attention over the last several years, indeed decades, the new executive order asks agencies to try to harmonize, simplify, and coordinate rules. It emphasizes that some sectors and industries face inconsistent, overlapping, and redundant requirements. To reduce burdens and costs and to promote simplicity, it calls for greater coordination across the federal government. That is designed explicitly to promote innovation. Fourth, the new executive order asks agencies to consider flexible approaches that maintain freedom of choice for the public. Approaches that are choice-preserving include, for example, provision of information rather than foreclosure of decisions through mandates and commands. This is a plea, more than a plea, a direction for flexibility. Fifth, as noted, Executive Order 13563 calls for scientific integrity. It directs each agency to ensure the objectivity of information on which it relies. Sixth, and finally, what's been most publicized in the weeks since the executive order was signed, it calls for retrospective analysis of existing rules. It is concerned about rules that may be outmoded, ineffective, or excessively burdensome. It directs agencies to produce preliminary plans for periodic review of significant rules and to submit them to the Office of Information and Regulatory Affairs within 120 days, a pretty tight time frame. In this way, the executive order is aimed at the stock of existing requirements as well as the flow of new requirements. Both are covered by the new executive order. The Presidential Memorandum on Small Business and Job Creation emphasizes the essential role that small businesses play in the American economy. With job creation in the title and economic growth in the body of the memorandum, The President has insisted, as he wrote in the Wall Street Journal, on federal agencies doing more to account for and reduce the burdens regulations may place on small businesses. To do that, he has emphasized the requirements of the Regulatory Flexibility Act and directed agencies specifically to explain themselves whenever in proposed rules or final rules they fail to provide flexibilities to small businesses in the form, for example, of partial or total exemptions, simplified reporting requirements, or delayed compliance dates. Taken as a whole, Executive Order 13563 and the new memorandum on small business and job growth create strong foundations for improving regulation and regulatory review. I'm looking forward to answering your questions.
I thank the witness. Let me, before we start, perhaps set the tone here. You saw that, Mr. Sunstein, we've sort of changed the rules here to sort of expedite things, and it's important, I think, to stress that the members' questions that they're going to ask, that we get a direct answer from you. All of us have been in hearings where we just have 5 minutes, and it's very difficult to get an answer. And I think the fact that the questions that are going to be asked you reflect that we're willing to do away with our opening statements so we can provide more for testimony and questioning. Therefore, I just ask to make it as productive as possible if when you answer the questions, you can answer yes or no. Some members will ask you these type of questions, and I know it's going to be difficult, but we ask that with your patience and forbearance that you would answer yes or no to these questions, and I thank you in advance for doing that. And with that in mind, let me be the first one to ask you questions. The Obama executive order was issued, but the comments from organizations representing all the stakeholders and the job creators in this country, a lot of them are concerned that with the Obama order, there was a lot of independent regulatory agencies were not part of the OIRA review. So my question for you, Mr. Sunstein, is under the regulatory actions of the independent regulatory agencies, such as the SEC, the FCC, the Federal Trade Commission, FERC, and others, subject to OIRA regulatory review, are they? Yes or no?
No.
Okay. I'm also concerned what appears to be sort of an amorphous type of standard that was articulated by the President. This is what is quoted in the executive order. Quote, where appropriate and permitted by law, each agency may consider and discuss values that are difficult or impossible to quantify, including equity, human dignity, fairness, and distributive impacts. Now, these are all subjective terms. So you're going to make a decision on regulatory reform based upon human dignity, fairness, and distributive impacts, which I assume means distribution of income. Is that my interpretation correct? When you say distributive impacts, yes or no, does that mean distribution of income?
That wasn't our...
Okay, you're saying no, okay. But these standards, I mean, just looking at it, mean any rational cost-benefit analysis is going to be tossed out the window instead of saying, what does this economically make sense, which you can quantify. These agencies are going to be using these amorphous type of ways to determine whether economic value is determined for a regulation. And they're subjective, as you know. We're all inherently involved with either ideology or political correctness. So I guess the question is, won't these standards make it very difficult for any rational cost-benefit analysis to be implemented?
That would be a no.
Okay, all right. That's enough. Okay. On April 2010, the administration had issued 190 economically significant regulations or regulations having an economic impact of 100 million or more. Is that correct?
I'd want to double-check that number.
Sure, I appreciate that. And by December, that number was up to 224.
I'd want to double-check that number as well.
So the number of regulations the administration is issuing in our opinion, humble opinion, is rising, not falling. Just a comment.
No, that's actually not true. The number of regulations issued in the last 2 years is about the same or slightly lower than the last 2 years.
And if you could just follow up with the information to confirm what I asked you earlier, that'd be helpful.
Absolutely. That would be yes.
Okay, yes. Okay, good for you. All right. Okay, so in our opinion, these numbers represent a new amount of regulations, including regulations into, I think, new areas, such as the FCC regulation of the Internet for the first time. Will these regulations that have been issued in the last 2 years be subject to review under the President's new standard?
Yes.
Okay. And we expect to see more regulations issued by Health and Human Service to comply with the new health care law, new financial regulations to comply with the Dodd-Frank law, and new regulations from the EPA. Now, will these regulations be subject to review by OIRA?
I believe you referred to non-independent agencies.
Right.
And thus the answer is absolutely yes.
Okay. What we've seen from the administration the last 2 years to be what, in our opinion, is not a full exercise and responsibility to review these regulations. Are you aware that in the first 2 years of the Bush administration, the agency issued 19 return letters to agencies, letters rejecting agencies' regulations, while this administration has issued zero return letters in the same period?
I'd say yes, I'm aware of that. Would you like an elaboration?
We'll keep going here. I think when the Democrats have a chance, they're going to give you a chance for elaboration. Okay. Given that we have seen agencies respond to the executive order by stating that they don't need to make any changes, I think this is what really concerns me and seems to change anything in terms of how much control your office will really have. I mean, I think, you know, as a Congress, we reach out to bureaucracies, and lots of times we see these bureaucracies unable to act. Back in 2003, in your book, Risk and Reason, you wrote, quote, "All in all, President Clinton's executive orders did not seem to have much impact. OIRA was largely passive and toothless, serving a coordinating function without trying to steer regulation in any particular direction," end quote. That's your quote in your book. The President's new policy reaffirms this very executive order you've referred to as toothless and not performing. In our opinion, would you think that what you said in your book is applicable to what happened under the Obama administration?
Absolutely not.
Okay. Let me just ask my last question here. Do you have our book there in tab 3? In the binder before you is the President's memorandum of January 30th, 2009 on regulatory review. In it, he directs the director of OMB to produce within 100 days a set of recommendations for a new executive order of federal regulatory review. The question I have for you is, were the set of recommendations produced within 100 days
Yes.
of the President's directive?
Yes.
Okay. That completes my time. And Mr. Gett.
Thank you for enabling me to be brief.
That concludes my opening statement and my questions. Mr. Gett.
Thank you, Mr. Chairman. Opening statement might have been a better description. We actually, on the minority side, we'd actually like to hear some answers to some of these questions. So, Mr. Sunstein, I have a series of questions I'd like to ask you. The first one is, OIRA was created in 1980 to oversee certain agencies, correct?
That is correct, by the Paperwork Reduction Act.
Yes, and it was created by Congress, is that right?
That's correct.
So President Obama and the administration could not, in and of themselves, change the jurisdiction of OIRA. Only Congress could do that, right?
That's correct.
And all of these agencies that Mr. Stearns mentioned that are exempt from the President's executive order are exempt from it because OIRA does not have congressional jurisdiction to oversee those agencies, correct?
The basic answer is yes, but if I can elaborate slightly,
Sure.
if you permit. Under the Paperwork Reduction Act, OIRA does oversee the independent agency's information gathering requests, and actually we've taken strong steps in the last months to try to reduce paperwork burdens on the American people, including from the independent agencies. With respect to the applicability of the executive order, what President Obama has done is followed the practice of President Reagan, who initiated the application of the executive order to the executive agencies because of legal and political concerns about overreaching presidential authority. Both President Bushes went along with President Reagan on that issue.
Okay, thank you. Now, I want to talk for a few minutes about an issue that I think we're going to be hearing a lot about in this subcommittee, and that is the EPA regulations. The first target that I've heard about is large industrial boilers and the EPA proposed regulation to limit the emissions of toxic air pollution like mercury, lead, and dioxin. Are you familiar with that proposed rule, Mr. Sunstein?
Yes.
And are you aware that EPA's proposed rule would potentially save thousands of lives per year and protect children from neurotoxins because the benefits are projected to be about 14 times greater than the cost?
I don't have the exact numbers before me, but I am aware of numbers in that vicinity in the proposed rule.
Okay. Did the administration engage in an open regulatory process in working on promulgation of that rule?
Absolutely, and it continues.
Yeah. In fact, the chairman of this committee has said that there were flawed regulatory tactics. So I want to talk for a minute about the EPA process that you just referred to. After proposing the rule last April, EPA received over 4,800 comments on the proposal from stakeholders, including a large amount of data from industry on the capabilities and costs of various pollution control options. Are you aware of that data that the EPA received?
Yes, I'm aware of the sheer volume of comments.
Okay. And are you aware, sir, that in September, Administrator Jackson of the EPA sent a letter to Congress indicating that the EPA was going to give more time to look at this because there were so many comments that were being received?
Yes.
And are you aware that on September 7th last year, EPA asked the court for an extension of time to continue the process, but the extension given by the court was only very short?
Yes, 30 days.
30 days. And are you aware that the EPA has suggested that if all of the comments cannot be addressed in the final rule, the parties may petition the EPA to reconsider the rule, and the EPA has the authority to stay the rule pending the reconsideration. Is that correct?
I remember something very close to that, and that may be precisely what the EPA said.
Okay. Now, do you think that the EPA's efforts to respond to the comments on the proposed Boiler Act are in line with this executive order that's the subject of this hearing today?
I would say very much that the EPA's careful consideration of public comments is in line with Section 2 of the executive order.
Section 2. Okay. Do you think that the EPA's request for an extension was in any way an admission of failure of the regulatory process?
No.
And can you explain why you believe that?
Well, it's perfectly legitimate, as some of the opening comments have suggested, to try to take account of public concerns and comments, to respond to stakeholder data or stakeholder perspectives, and sometimes that takes a long time. There's a trade-off between doing things fast and doing things right.
And finally, do you think that criticizing the EPA's efforts on this rule is consistent with calls for greater process and transparency?
What I'd say is that greater transparency is exceedingly important, and the EPA's effort to take account of public comment is admirable.
Thank you. I yield back.
Thank you, gentlelady. The chairman of the full committee, Mr. Upton from Michigan, is recognized for 5 minutes.
Well, thank you, Mr. Chairman. And again, I want to compliment you on the hearing. As I learned when I was chairman of the Oversight and Investigations Subcommittee, we are to identify problems and then come back with legislation to fix them. And I think that what is happening, finding a number of agencies that are exempt from OIRA's process, is something we ought to look into, and we ought to come back with bipartisan legislation to fix that. Give this administration and any future administration the ability to oversee all the regulations that are there. No agencies should be exempt. I want to compliment the President's Wall Street Journal editorial piece from this last week. I think many of us here would agree with some of the comments that he said when he wrote that we have to have the proper balance. Sometimes these rules have gotten out of balance placing unreasonable burdens on business, which has had a chilling effect on growth in jobs. We need to promote economic growth. Sometimes regulations are not worth the cost, and which is just plain dumb. I think a number of us welcomed that piece. But I want to go back to the boiler MAC regulations here for a moment. EPA, as you know, estimated that the new rules would impose new capital costs of $12.6 billion, annualized costs of over $3 billion. A study by the Council of Industrial Boiler Owners concluded that the true economic cost would in fact be $113.5 billion. The rules would place some 337,000 or more jobs at risk. So, as you know, on January 21st, the court rejected EPA's request for a 15-month extension. It was the administration's request, EPA's request, to finalize the Boiler MAC rules, and directed EPA to issue final rules by February 21st. My first question is, when OMB cleared the proposed rules last year, did OMB have concerns about the economic impacts given the state of the economy, particularly related to the numbers that I just cited?
Any rule that imposes significant costs, we have significant concerns about.
Is OMB now working with EPA to make changes to bring down the costs and to ensure that the final rules will not put those risks?
The EPA said in court filings that the rule would look significantly different, the final, and we are working closely with EPA to try to put it in the best form possible. And that work will be undertaken in line with the President's executive order, which calls for careful attention to cost.
So knowing that this had been, all the comments that had been there, all the work that had been done, particularly this last year, the admonition, in essence, by EPA in December that we need 15 more months, you believe that you can do all that work in the next 3 weeks?
It would be premature to say exactly how much can be achieved in the next 3 weeks.
I used to work at OMB, so I know how many people are there.
I know you did. You know how hard people work. What I would say is that engagement with affected stakeholders, with you, with members of your staff, is most welcome in the period we have. That EPA is, as the earlier line of question suggests, completely alert to the concerns that have been expressed about costs. The administrator's been clear on that. And we're going to do the best we can to get it right and to keep the cost down, to take account of objections and perspectives in the time that remains, and look forward to working with you on that.
All right, a question that I have, knowing that you've got 3 weeks to go, would OMB welcome a congressional delay to give the agency more time to do its work on the rule that EPA, in essence, said, give us 15 more months? I mean, it's just hard to believe that EPA says, we need 15 more months. The court says, no, you're going to follow this. You're going to do it in 30 days. You're now exercising some baseball bat to say, no, we're going to get it done in 3 weeks, even though your agency says 15 months?
Our focus, as your question suggests, is on implementing the law, taking account of costs and concerns, and complying with the court order. That's what we're focusing on. With respect to congressional responses, that's not exactly my lane. We're going to focus hard on implementation and try to get it right.
So the last question, would you like to have more time if given the opportunity?
We agreed with the EPA that to get more time of the length that the EPA sought was a very reasonable request. So the EPA's request to the court, we supported.
Okay, yield back.
Thanks, distinguished chairman. Recognize Mr. Gett.
Mr. Waxman.
Thank you very much, Mr. Chairman. Mr. Sunstein, I appreciate your answers. That question that was just being pursued was over the boilers under the Clean Air Act. Now, let's not forget the purpose of it. The purpose of the regulation is not to cost a lot of money to business, which might lead them to reduce jobs. The purpose is to reduce mercury and lead damage, which, when it affects our children, can lead to lack of brain development. Dioxin causes cancer. These industrial boilers are the second largest source of mercury emissions in our country. So when EPA has proposed a rule, it's got to be reviewed in terms of the costs and the benefits. And at the same time, under your new procedures, you're trying to even fine-tune it to be sure it's the least costly way for business to comply. Isn't that correct?
Exactly.
Now, I know that no one here would support duplicative and pointless regulations, but I worry a lot of what we're going to hear the rest of this hearing are not those regulations. They're going to single out important regulations. Some Republicans are even saying that we shouldn't regulate the most abusive and risky Wall Street practices, even though those practices ended up nearly driving our economy over a cliff. Regulations don't just prevent harm, they can also help our economy. And the boiler one was to prevent harm, but there are some regulations that really are important for business. One example of that is a carbon pollution standard for vehicles issued by the EPA and the National Highway Traffic Safety Administration, April 2010. I understand that these standards improve the national security by reducing our dependence on oil. They reduce carbon pollution and improve public health. They save consumers a lot of money, far more than manufacturers will spend building more efficient cars. I understand that these rules will save 1.8 billion barrels of oil. Is there any other action by this administration or its predecessors that's even in this ballpark in terms of reducing our oil dependence?
Offhand, I don't think there is an example that's as impressive.
So this regulation is to reduce our dependence on oil, and in fact, as a result of it, for the first time, America's oil consumption is flat. Right now, even though the DOE has regularly said that our consumption of oil was going to go up, it's not increasing. We're projected to use less oil in 2020 than in 2007. So if we're concerned about oil exports, propping up unsavory governments around the world, which is certainly the case, then this rule is very good news. Mr. Sunstein, I also understand this rule will reduce U.S. greenhouse gas emissions by 960 million metric tons, reducing overall greenhouse gas pollution from light-duty vehicles by about 20% by 2030. How does this compare with other actions this or other administrations have taken to tackle the climate issue?
I think this is the prize winner on that count as well.
So these benefits don't cost the consumer a thing. In fact, they save consumers money. Majority of consumers will pay less overall for running their cars. On average, consumers will save $3,000 over the life of the vehicle. You're a nationally acclaimed expert on cost-benefit analysis. Are these estimates solid? Will people really be better off with these regulations in place?
We don't have any serious question that this rule survives cost-benefit balancing.
My understanding is that these cost savings are based on assumed gas prices ranging from $2.61 per gallon in 2012 to $3.60 per gallon in 2030, and we're seeing gas prices go up. In fact, if they go up, it will produce even greater net benefits of roughly $140 to $190 billion. Now, we've talked about the benefits to our national security and the environment, but the rule also benefits the auto industry because it will harmonize state and federal standards across the country, and that's why the industry strongly supported these regulations. It provided certainty for them, clear path for innovations, and it will make their job better as they try to innovate. EPA's contribution to these standards produced benefits 30% higher if we just had the NHTSA portion in place. Any effort to remove the EPA standard or its statutory authority would severely undermine the benefits of this rule. This is just one example. Overall, the benefits of the Clean Air Act vastly outweigh its costs by a ratio of 32 to 1. Rather than being a drag on the economy, These critical regulations improve our lives just as they're intended to do, and that's the whole point of having regulations in the first place. Thank you very much, Mr. Chairman.
Thanks, gentlemen. Gentleman from Texas, recognized for 5 minutes.
Thank you, Mr. Chairman. Time is impeccable. I'm supposed to be doing a live radio interview right now, so we planned it very carefully that I can't do that. There has been an explosion of regulation and regulations issued in the first years of the Obama administration. Quite frankly, I don't see that your organization has done anything to slow that down. I don't see that you've done anything to actually do what the existing executive order says. What gives us the confidence to think that this new executive order is going to be any different? Does this executive order require, or will your office require, agencies to determine the net job gain or loss of past, current, or new regulations?
Okay, if I may, can I discuss the idea of explosion? Actually,
I'll discuss it very quickly because I've only got 3 minutes.
I'll be very fast. And the number of regulations issued in the last 2 years is approximately the same as the number of regulations issued in the last 2 years of the Bush administration. The total costs of regulation in the last fiscal year are lower than the total costs of regulations in the executive agencies in fiscal year 07.
Just the regulations issued under the new health care law are in the thousands.
The number that have been issued in the last months are not in the thousands. So in terms of finalized economically significant rules, I don't think the data supports the claim.
Well, what's the answer to the question? Is this new executive order going to require a determination by your group, your agency, of the net job gain or loss of past, current, and new regulations?
We will be focusing very much on job loss as a result of regulations. The executive order...
So the answer is yes?
There are some technical reasons it's complicated.
So the answer is no.
Well, I'm afraid that the answer is to this one uniquely thus far is neither yes nor no.
Well, that's a very evasive answer, and the President's going to give you an A+ for evading a straight question.
Well, if I can explain...
But let me go on because I've only got 2 minutes and 39 seconds. You're aware of, I'm sure you're conversant with the endangerment finding that was issued the first 90 days by the EPA administration?
I'm aware of it.
Are you aware of any cost-benefit analysis that went into that endangerment finding?
A scientific finding is not a regulatory action.
So the answer is there was none?
It couldn't be at that time.
Okay.
The regulatory action that followed the scientific finding was full of cost-benefit.
Do you agree that that endangerment finding, if actually implemented, would cost millions of jobs to the U.S. economy and hundreds of billions of dollars?
The endangerment finding by itself costs no money and no jobs. It's a scientific finding.
That's not my question.
If implemented, meaning if followed by regulatory action?
Well, if implemented, if actually put into practice.
Well,
every independent analysis has said it would cost millions of U.S. jobs and hundreds of billions of dollars
what I'll tell you
per
is
year.
What we in the EPA are determined to do, and with the new emphasis in the executive order, which I'm grateful for your enthusiasm for, is to try to minimize burdens.
Okay. Well, I have 1 minute and 13 seconds. In Monday's Wall Street Journal, an EPA spokesman was quoted as saying that President Obama's new executive order that you're here to testify on will not affect the EPA at all. Do you agree or disagree with the assertion of the spokesperson at the EPA?
The executive order will affect all agencies to which it applies, including the EPA.
So you will send a letter to the EPA and inform them that they are going to be subject to this order?
It's clear on the face of the executive order that the EPA...
So the EPA spokesperson just misspoke?
I'd like to see exactly what the EPA spokesperson said, but it's as clear as day.
It's clear as day.
That the executive order applies to the EPA.
All right. My last question, would you support an amendment to the Clean Air Act that would require the EPA to do a true cost-benefit analysis of any proposed regulation it proposes to implement under that act?
We are in favor of cost-benefit analysis of any regulatory action, and that's already required by the executive order.
So the answer to that is yes.
With respect to legislative action, that's not quite my lane. We're in the implementation business. So on the general idea of cost-benefit analysis for regulatory actions, absolutely.
Thank you. I yield back.
Thank you, gentlemen. The gentleman from Michigan, Mr. Dinkle, is recognized for 5 minutes.
Thank you, Mr. Chairman. I'm interested in the last question just raised. Under the Clean Air Act, EPA is required to consider first the health implications, and second, the best and the most economic way of accomplishing that purpose. Is that right?
Depends on the provision.
Yes or no?
Not quite. No.
Oh, yes, quite, because I helped write that
No,
law.
if you want a yes or no answer, no, that's not correct.
What's wrong with it?
Under the National Ambient Air Quality Standards, cost is not relevant. It's only a scientific determination.
Dearly
Under the-
beloved friend,
Sorry?
I said that the first step taken is to comply with the law and address the health care questions. The second question that is then is addressed is to do it in the most efficient and economic way. Is that right?
I don't think that's quite right either
Well,
for the new source performance
I would
standards.
suggest strongly you go back and take a look at it because that's the way we wrote it. Now, let me go into some matters here of concern. OIRA is required under the executive order to submit a preliminary plan to review rules and regulations for the purposes of modifying, streamlining, expanding, or repealing. Do you believe that 120 days is sufficient time for the agencies to conduct such a review and to prepare an appropriate plan? Yes or no?
Yes.
All right. Next question. Will these plans be subject to public notice and comment requirements of the Administrative Procedures Act?
It's not a rule, so no, but we do hope to have a high degree of public engagement.
Well, the Administrative Procedures Act requires these things to be subject to public notice and comment, does it not?
Rules. No, it does not apply to preliminary plans.
All right. Now, will the agencies be required to have a public notice and comment period for any rules or regulations that are withdrawn or repealed? Yes? or
Yes.
no? Given the intent to reduce federal non-security spending in fiscal year 2008 levels, do you believe federal agencies will have the funding necessary to complete the required look-back of existing rules and regulations? Yes or no?
Yes.
Do you believe that the agencies have the personnel resources necessary to complete the look-back and do the other things that they must do?
Yes.
Yes or no? Do you anticipate that the regulatory reviews, for example, by the Department of Health and Human Services, will prevent the agency from completing the rulemakings required in and hinder the general implementation of the Affordable Care Act? Yes or no?
No.
Similarly, will regulatory reviews prevent the Food and Drug Administration from completing the rulemakings required in and hinder general implementation of the Food Safety Modernization Act passed by the Congress in the last session? Yes or no?
No.
Thank you, Mr. Chairman. I've stayed within my time.
Thank the gentleman from Michigan. We're recognizing next Mr. Sullivan is recognized for 5 minutes. We have a vote, and we're going to continue on, and then I urge everybody to come back. We need just a couple of members. We can continue, so we'll adjourn after this and vote and then come back, and then we don't have a series of votes, I think, till 3 o'clock, so we should be able to get through the hearing.
After the vote, okay. Okay.
So you recognize Mr. Sullivan.
Thank you, Mr. Chairman, and thank you, Mr. Sunstein, for being here today. The EPA responded to the President's new executive order last week by saying that they were confident it wouldn't need to alter a single current pending rule. EPA's statement went on to say that, in fact, EPA's rules consistently yield billions in cost savings that make them among the most cost-effective in government. Do you agree with the EPA's statement on this new executive order review rule?
The executive order applies to the EPA. The retrospective analysis it requires is new, so the EPA will have to do something new, and it welcomes that retrospective analysis. And the various provisions of the executive order emphatically do apply to the EPA.
So that's yes.
Well, anything involving greenhouse gases or air pollution or water pollution, and what I'd want to emphasize is the provision calling for integration and harmonization. So sometimes sectors and industries are faced with overlapping and redundant requirements, and EPA, I know, welcomes the opportunity and direction to try to promote greater simplicity, reduced burdens, and greater certainty, a point which has had a lot of emphasis in this hearing.
Do you believe that all of the pending economically significant rules before the EPA as currently drafted will yield taxpayers savings? There's 8 of them are $1 billion each.
I have to look at them all to make a judgment.
Are you involved in that process, though?
We look at them when they come over, typically, to our office. So the ones that are in the early stages of development, where sometimes the EPA won't even decide to send the rule over because it needs to do more work, we don't typically engage with the agency before they have something that they're able to submit to us.
Do you believe that all of the pending rules before the EPA is currently drafted will create jobs, which we need desperately in this country?
It would be, I do not believe that every rule that any agency is considering is likely to create jobs.
So the answer is no?
I do not believe that every rule that the EPA is considering is likely to create
Do you
jobs.
disagree with the EPA then, for example?
I'm reluctant to disagree with newspaper accounts of spokespeople. So I need to see the quotation, and I need to see what its accuracy is. It is true that a number of EPA rules have benefits well in excess of costs.
And your boss seems to think that too.
Seems to think a number of EPA rules have benefits well in excess of costs.
No, that he's concerned about our economy, that some of these regulations might hurt jobs.
We very much, you're exactly right, Congressman. That is our focus. That's the focus of this executive order, to make sure that regulations are helpful to economic growth.
I hope so. The President's new executive order says that agencies must consider equity, human dignity, fairness, and distributive impacts in determining cost-benefit of regulations. I have no idea what that actually means in bureaucratic language, but say, for example, your cost-benefit tests impose $100 billion in hard costs to the economy, but supposedly result in a $1 trillion increase in human dignity. What does this mean? And please explain this to me, as I have several companies in my district. Mr. Gardner pointed that out. They're scared to death. They really are. They bring this up all the time. Town hall meetings in my office. Chemical companies. I'm from Oklahoma. Energy companies, trucking companies. And how do I explain all this gobbledygook stuff that you talk about? I mean, can you break it down on simple terms for me so I can go home in Oklahoma and
I'm
talk about this?
extremely grateful for that question because it's very important, and I understand the concerns to which it might give rise.
There's a lot of concerns.
Yes. Let me explain, if I may.
It's the most concerning thing to this economy and business right now.
I think it ought not to be, but let me explain why. The sentence right before the one that refers to human dignity says quantify in the most accurate way possible costs and benefits using the best available techniques. That's a firmer statement in favor of quantification than any American president has made. With respect to equity, here's an example. We have a rule that's been proposed that involves children being run over. Often, this is an immense tragedy, by their own parents because there isn't visibility. They can't see behind in the cars. And we had parents begging Congress to have a law that would save the hundreds of children from being killed in those accidents. This rule, which is directly implementing a statute, it's about equity. It's about children typically. I have a son myself who's not quite 2. The children are typically around that age, just learning to walk and getting hit. That's about 45% of those who are hurt in those accidents. That's equity. That plays a role. With respect to human dignity, we do not mean this as an all-purpose qualifier of cost-benefit analysis, which is the foundation of the executive order. We do mean it as a recognition that if you have a regulation or a law that's helping people who are wheelchair-bound, often they're veterans, by the way, to have access to bathrooms, There's a dignitary concern there. It's about human dignity, not just about...
I understand it, but someone keeping their job is dignity too.
Absolutely. And
It's
that's
a
why
dignified thing to do.
That's why job creation is in the first sentence of the executive order.
Well, thank you. I yield back.
I thank the gentleman. We'll temporarily put the subcommittee into recess till 11:40, 11:35, 11:40. And coming up on the Democrat side is Gonzalez and Mr. Green. And then on our side would be Burgess and Blackburn. So I urge everybody to return.
Thank you.
Appreciate your indulgence. The subcommittee reconvene, and the chairman recognized Mr. Schakowsky from Illinois for 5 minutes.
Thank you, Mr. Chairman. I wanted to thank you, Mr. Sunstein, for mentioning the requirement now to have some rearward visibility in cars. Along with Republican Peter King of New York, that was my legislation that would require some rulemaking, and I'm very grateful for the lives that will be saved and injuries that will be prevented because of the regulation. I'm wondering, you know, one way to judge, I suppose, how we're doing with regulation is just to count the numbers. But I think another way would be to look at what are the net benefits of those regulations. And I'm wondering if you could describe that and perhaps even compare that to prior administrations.
Thank you for that question. In the first year of the Clinton administration, the net benefits of final regulations were minus $400 million. In the first year of the Bush administration, the net benefits of regulations were minus $300 million. In our first year, 2009, the net benefits of regulations were plus $3.1 billion, and it's going to look a lot better for 2010. So our net benefits are way ahead of our predecessor administrations. In terms of human realities behind the numbers, which your question points to, the rear visibility rule, which hasn't been finalized yet but it has been proposed, will save hundreds of lives or serious injuries, a plurality of which occur to children. We have a rule involving salmonella and eggs, which will prevent 79,000 diseases, protect Americans from a number of whom would die without the rule. We have rules involving stopping distance for trucks so they don't crash into people, so they stop more quickly. This will save hundreds of lives. So we are looking very carefully at the cost side, but as your question suggests, it's sometimes worth incurring a cost if you can save significant lives, prevent injuries, prevent diseases and illnesses.
I'd also like you to describe the process. Clearly, OIRA doesn't always agree with regulations that are proposed. And again, there's a number of ways to measure that, but I'm wondering if you could describe your process and what the effect has been when you don't agree with regulations that have been proposed.
Thank you for that question. The OIRA process, which has been built up really since President Reagan and has had bipartisan approval, involves agency submission of rules, proposed or final, to the Office of Information and Regulatory Affairs, and then we coordinate a process of interagency analysis. So different parts of the government with different perspectives and expertise will weigh in on the proposed rule, and we have a period when the proposed rule is with the Office of Information and Regulatory Affairs when we are available to members of the public, including stakeholders, including congressional staffs, who can come over to us and frequently do to weigh in on rules. There was a reference to the return letter and the absence of one from the Obama administration thus far. That's a nuclear option. And if you look at the practice under the Bush administration and the Clinton administration and the Bush administration before, the return letter is a very rarely used tool. I think the median number in the Bush administration, certainly in its last 5 or 6 years, was 1 or 2 for thousands of rules. What more typically happens is a collaborative process by which the agency responds to the concerns expressed in the review process. And in our administration, 75% of the time, 3/4 of the time, the rule has been concluded on, meaning approved, consistent with change. Meaning in the overwhelming majority of cases, when the rule is concluded on, it's been altered, not necessarily by the Office of Information and Regulatory Affairs, but as a result of the process, typically by the agency itself, which sees maybe there's a less burdensome way to do it. Maybe we can cut costs this way. Maybe this will have less of an adverse potential effect on jobs. Also, agencies not infrequently withdraw their rules when they conclude, on the basis of what they've heard, that it's not appropriate to go forward. And the withdrawal is a much more collaborative and constructive approach than the return letter. And I'm sure previous OIRA administrators would agree with that. We've had, at last count, 99 rules that were submitted to the Office of Information and Regulatory Affairs withdrawn.
So the record of this collaborative effect is to actually get rid of some potential rules and to significantly change a number of them.
Absolutely.
In the very few seconds I have left, let me just associate myself with the President's remarks yesterday that he would not hesitate to enforce common sense safeguards to protect the American people. That's what we've done in this country for more than a century, and I think that's the way we should go forward. So thank you very much.
Thank you, gentlelady. Gentlelady from Tennessee, Ms. Blackburn, is recognized.
Thank you, Mr. Chairman. I appreciate that, and I thank our witness for being here. I do have about 3 questions that I want to move through as quickly as possible. We have discussed these orders that have been given, and one is entitled Regulatory Flexibility, Small Business, and Job Creation. In it, the President states that his administration is, and I'm quoting, firmly committed to eliminating excessive and unjustified burdens on small businesses, end quote. Now, this is important to me because small business is our main employer in Tennessee. So, as the President states in his memo, isn't it true that eliminating burdens on small business is the purpose of the Regulatory Flexibility Act?
Absolutely correct.
Okay. Under this act, if any agency's proposed regulation will have a, quoting from the act, significant economic impact on a substantial number of small entities, end quote, an agency must conduct a regulatory flexibility analysis, correct?
That's correct.
But isn't it true that in the vast majority of cases, the agency does not end up performing that analysis because it determines that its own regulation will not have a significant impact on small businesses?
That is correct, with the qualification that the agency's determination to that effect is subject to public and internal scrutiny, including from the Office of Advocacy, which is an important partner in the regulatory process.
Well, I would point out to you also that a GAO report showed that 89% of its rules were certified as not having a significant impact. This is from the time period from 94 to 99. So the EPA was doing the analysis only 10% of the time. So do you have any current data on how often agencies are making this determination and therefore avoiding the requirement to fulfill that regulatory flexibility analysis?
I don't have a number offhand, but we can
Would
get
you
that for
submit for the record?
Absolutely.
Okay. Also, in the memo regarding small business, it directs agencies to give, quoting, serious consideration to reducing burdens on small businesses only in those cases where the agency is conducting a regulatory flexibility analysis, correct?
That's correct.
But since these agencies rarely do it, it sounds like this memorandum won't really have much impact on small businesses. Do you agree with that?
No, that I don't agree with. And you can just see in the last week, 2 rules from the Occupational Safety and Health Administration have been withdrawn in order to engage with small business.
Do you make the determination that those withdrawing those has a positive impact on small businesses' ability to conduct business?
I don't personally make a determination that the withdrawal will have a positive impact, but the Department of Labor...
But, sir, you are our witness today. Second question I'd like to go to with you. One of the protections for small business found in current law is the Small Business Regulatory Enforcement Act. And under that act, EPA and OSHA must notify the SBA before publishing the regulatory flexibility analysis for a proposed rule so that an advocacy panel, which you just mentioned, can be convened to review it and provide feedback on its impact on small business. Recently, the new governor of Tennessee, Bill Haslam, issued a 45-day freeze on all new regulations and rules as part of a top-to-bottom review to fully understand new burdens being placed on businesses in our state. Regulatory reviews like the one that Tennessee is undergoing are important because states and small businesses are concerned that agencies are ignoring their feedback and the feedback that comes from the advocacy panel. I do think this is a problem that you all have and needs to be addressed. Here's an example. The EPA did not follow the recommendation of the advisory panel with respect to the Boiler Act rule, instead issuing a standard that many small businesses feel and have spoken out on that it is impossible to satisfy regardless of the cost. So who reviews the agency's decision with respect to how it considers the panel's advice? Does IRA do that? What's the role here?
We participate in that. There's a group. We participate in that. And you can be confident, given the recent presidential memorandum and executive order, and not just that, but concrete actions in the recent past, that the concerns of small business will be very much taken into account.
Your consideration of it, do you consider it to be objective or subjective?
Consideration of the significant impact on a substantial number?
Yes.
To the best of our ability, that is an objective determination.
I have other questions. I will submit them to you in writing and ask for your timely response in writing.
You will have that.
Thank you, sir. Yield back.
Mr. Green's next. Sorry. Mr. Green, recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. Sunstein, some of the regulations that are raised the most ire of my Republican colleagues are regulations that are designed to implement the new health care reform law. In fact, you have to have regulations to implement a law, typically. I'm trying to think of an example that you don't. But Republicans have voted to repeal the entire law, but at a close look at these regulations shows that they will make insurance better and less expensive for patients for companies that provide workers with their insurance. On November 22nd of 2010, the Obama administration issued a regulation implementing the medical loss ratio provision of the Affordable Care Act. This regulation will make the insurance marketplace more transparent and make it easier for consumers to purchase plans that provide better value for their money. The guts of the regulation require that insurance companies provide more value for their premium dollar by actually spending your health insurance cost on health care. Such a novel issue for a health care company, I think, and to have a regulation that actually would require that, and not inflated administrative costs or excessive executive salaries. Ms. Sunstein, do you think that these rules would establish greater transparency and accountability for insurers, that they will guarantee Americans receive more dollar for their premium, more value for their premium dollar, and that they will even give more Americans a rebate of some of their insurance premiums? Now, again, without the regulations, that law would not be effective. Is that correct?
That's correct.
These are all seem that like they're good people who need health insurance. Isn't there a good example of regulations helping consumers, for example? Under regulation, another regulation put into effect as a result of health care reform law is the so-called grandfathering clause. This rule protects the ability of individuals and businesses to keep their current plan. It provides important consumer protections that give Americans, rather than insurance companies, control over their own health care. And it provides stability and flexibility to insurers and businesses that offer insurance coverage as the nation transitions into a more competitive marketplace in 2014. My question is, let me ask you about this rule. Isn't there a good example of regulations helping consumers and providing certainty for businesses?
Absolutely, that's a good example.
Can you give us any insight here where there have been so many attacks on common sense regulations that help consumers? you know, again, this is something that we have it in the law, and if the administration didn't promulgate the regulations, I think you would not be doing your job.
Well, we have a rule that's been issued that's going to help consumers make choices about tires by giving information. It's not a mandate. It's not very expensive, about safety, fuel economy, and durability. And that is part of consumer protection, providing information so that people can make their own choices.
Okay. There are rules, and these are good examples of how regulations can actually help the American public and our constituents. They give Americans better value for their health insurance dollar and give businesses certainty about the insurance that they're paying for their employees. It would seem like we should be cheering those kind of regulations instead of saying, no, we want to abolish them. Now, we can take votes up here, and you're not involved in that. But if you're not promulgating the regulations, again, the administration would not be doing their job. And that's true whether it's President Obama, President Bush, President Clinton, or all the way back to President Reagan, that promulgated regulations that was the intent of the law. Is that correct?
Yes. Our first obligation is to respect the law.
Thank you. Mr. Chairman, I have no other questions, but I'd be glad to yield my 1 minute left to our ranking member.
Oh, thank you for yielding. Let me just follow up on a couple of questions, or maybe one. Mr. Sunstein, you were asked earlier about the direction in the executive order to consider values that are difficult to quantify, like human dignity. Can you elaborate for about 40 seconds on the intent of this direction?
Yes, the idea is to recognize that under the law, as the previous question suggested, human dignity is sometimes something that agencies are supposed to consider. Just this week, the Department of Justice issued a rule involving rape, and in the analysis of the rule, the agency paid careful attention to monetizable costs and benefits. That's very important, but it recognized that the act of rape involves an assault to human dignity, and it's not reducible just to numbers.
Thank you.
Dr. Burgess is recognized. 5 minutes.
Thank you, Mr. Chairman. Mr. Sunstein, we were all grateful when the President signed an extension of the sustainable growth rate law in December. But I think, as we all recognize, access for our seniors to physicians of their choice is being adversely affected by what we know of as the sustainable growth rate formula, the formula by which Medicare pays physicians. Now, is it the President's intention to follow through on his promise that this formula abnormality be fixed in this 13-month time interval that we've given ourselves?
I greatly appreciate the questions. It's a bit out of my domain as OIRA administrator, but I have every...
You do work in Office of Management of the Budget, correct?
I do.
Is it likely to be in the President's budget request to Congress that there is some type of relief on the sustainable growth rate formula?
I'd have to defer to the Director of the Office of Management and Budget, lacking clarity on the right answer to that one.
Do you have a sense whether it is the President's commitment to follow through on this?
My belief is that anything the President has made a commitment to, he's likely to follow through on.
Well, as you know, I mean, the price tag for this varies depending upon who you talk to, but you get figures from $200 billion to nearly $400 billion over the 10-year budgetary cycle. Do you have an idea, a sense as to what programs the President is looking at cutting or replacing in order to come up with this figure?
Actually, on the budgetary side, there's an army of people who are working, and that's not a side that the Office of Information Regulatory Affairs works with on that level, at that level of detail. So in particular budgetary requests, we're respecting the workload of others.
Perhaps we can get that information from another source, but I do want you to understand that the administration has made a commitment on this, and America's doctors are looking to the administration to fulfill that commitment. On the issue of regulations, there was an entirely new federal agency that sprang up like mushrooms after a spring rain after the health care law was signed, and this was the Office of Consumer Information and Insurance Oversight. I talked to some of the people who were at the head of that agency in the fall, and they could not identify for me where the authorization language existed in the Patient Protection Affordable Care Act for that new federal agency. I asked if there were not other areas of HHS that might do this same activity, and they said, oh no, this is an entirely new activity that we will be undertaking. Never before has the federal government regulated private insurance on a national level. That's always been left up to the states. So in this new climate of regulatory reform, is this a good idea to be going in this direction?
As I say, the lane of the Office of Information and Regulatory Affairs is relatively narrow, so issues of organization within HHS or DHS or others.
Well, let me interrupt you. Never mind that, because they actually have reorganized since we started asking questions, and it's now in a different part of HHS. But just overall, if we're looking at a new climate of perhaps easing some of the regulatory burden, your words, not mine, is it a good idea to be instituting an entirely new federal agency that will perform this function?
What I would say in the spirit of the executive order just signed is that any decision with respect to regulation should be connected with the principles that the President has laid out, and that includes structural decisions.
Well, of course, it would have been helpful if we could have had those individuals in front of us for an oversight hearing during the fall. We were not permitted to do that. I suspect we will be now under Chairman Stern's leadership. But again, in the interest of this new climate of regulatory reform, it seems like this is something where your office should take a direct interest. I mean, we're told, for example, that you can't sell insurance policies over state lines because that's always been a state-regulated function. And yet this individual was telling me that for the first time, there's now going to be a national regulation of private insurance that has never existed in this country before. If that's okay, then maybe it's okay that we sell insurance across state lines. That may be a logical follow-on that perhaps we should explore. But from the regulatory side, I do hope that your agency will take at least some passing interest and have some curiosity into this new agency that's been set up and now been absorbed into CMS, but it's still there. With the purpose is still there.
Yeah, appreciate it.
Thank the gentleman. Mr. Weiner from New York.
Well, thank you. Let me begin by congratulating you, Mr. Chairman, on this hearing. It is, you are showing you're running a very efficient, quick hearing, so quick, in fact, that it's uncontaminated by actual testimony from the witness in most cases. You know, this is what we're learning a little bit about this Congress, is that we've lurched so quickly into a very successful campaign by my Republican friends that all of the slogans are just being transplanted. We're having committee hearings, and we're starting to see the slogans don't really hold up. For all this talk about excessive regulation, the first thing that Mr. Eisen, another chairman of another committee, does says, hey guys, tell us if there are any regulations you don't like, because we don't know any. We hear my colleagues, particularly some of my freshman colleagues, talk about small business, always tell me about regulations and how bad things are. Well, let's take a look at the record. The record is that the Dow Jones has had a better year than they've had any time in the last 12 years, that we have now businesses sitting on over $1 trillion of cash that they've done pretty well with, that we've now created more jobs, more private sector jobs in 2 years of Obama than 8 years of President Bush. So this whole idea, oh my goodness, the crushing regulations, and then the first exchange between Chairman Stearns and Mr. Sunstein was interesting. He asked a question or stated postulated something. Mr. Sunstein rebutted it, and then he returned and said, well, let's assume I'm right. Well, okay, we can do that, or we can actually listen to the evidence. There are no more regulations in this 2 years than there have been in the past 2 years. But let me just ask, perhaps to put in context this idea of regulation. You know, no one likes bad regulations, but regulation to find the price on it is kind of a hard thing to do. For example, when there was this big effort on the part of financial services companies to change the capital requirements to allow them to keep less capital, have more debt on their books, they said that this regulation was costing us an enormous amount of money. Well, I'm curious, how do you calculate the cost of easing that regulation? Well, you got to count the TARP funds, $750-some-odd billion. But how do you count the pain that it causes some person who did nothing wrong, whose home is not foreclosed, who's not underwater, but lives on a block now with 5 foreclosed homes because capital requirements weren't lived up to? How do you count that? Let's assume each house is a $200,000 house. You can say, well, there's the $200,000 home that's foreclosed on, but how do you assess the value to the community that's lost the tax base? How do you assess the value of that homeowner who did nothing wrong, who took out no extra loans, but now his property values has plummeted 75%? How do you say to the rest of the economy, that small business guy, that because the bank has gone under, because that requirement has been eased, now he can't get a loan? The fact is, ladies and gentlemen, that these regulations are in place, and they seem so onerous and burdensome sometimes, but what they're intended to do is stop real damage to our economy. You know, the very same Wall Street people who advocated for the lessening of the net capital rule are the ones who are now unemployed. They thought they were doing a great, smart thing advocating to loosen that rule. We did it, and now their company, Bear Stearns, doesn't exist. Now, would you rather have a smart regulation and have a beautiful company that is employing lots of people and giving loans, or get rid of that burdensome, onerous regulation that requires this silly thing like they keep enough money in their bank before they start giving loans? Would you rather have a regulation that says all hospitals have to have electronic record keeping so they can share information, or do you want to try to figure out the cost that it is when someone's given the wrong drug and goes into seizure? Yes, it may cost a little bit more money to have these regulations in place, but if you're really going to do the mathematic calculation that Mr. Stearns alluded to and others have alluded to, how exactly do you do that? I think it'd be helpful, Mr. Chairman, for us to have a hearing on exactly how it is you assess these costs. Let's see how much the cost is on having a lead in toys regulation. Let's see, how do you figure out the cost of brain cancer in a 6-year-old as opposed to a 3-year-old? Let's put that on a ledger and see how that works out. But the regulation is so burdensome and onerous. Well, to that family, that is the difference between their child having a lifetime illness and not, you know what, that regulation seems okay. Maybe it's not so bad for a toy company to have to not put lead in their toys. So if we're really going to do the math, I think we should have a hearing here, perhaps when Mr. Sunstein can come back. He clearly has a lot he wants to get off his chest, and I'm not giving him much opportunity here either. But let's really see what that ledger looks like, and let's be honest about it. Let's get past the campaign rhetoric.
We are now recognizing, let's see, Ms. Myrick is recognized for 5 minutes.
Thank you, Mr. Chairman. I wanted to go back to the NHTSA rulemaking, and I'm going to ask you to submit some of this for the record because I've got another question and I'll be out of time, so I appreciate it. The proposed rulemaking that does say, you know, rear visibility system and then cameras inside the car, et cetera. Supposedly what I've been told is the accidents that did happen were in large trucks and SUVs and vans, bigger vehicles, where the rule says it has to go in every car. And my question on the cost-benefit analysis again, believe me, I don't want children to lose their lives. And I mean, there's nothing more imaginable than losing a child. And if we can save millions of lives, I support saving millions of lives. But when you look at the change that the administration says they want to do in the rulemaking and try and put cost-benefit analysis into it, the NHTSA's own modeling that they use says that it isn't beneficial to do it. And then the other question is, you know, if you do put this across the board to all the cars, does it raise the price of the cars to a point where people can't buy them, and then you've still got accidents because they don't have availability? So for the sake of time, if you would be willing to answer that for me to submit for the record, and then also, did you have consultation with NHTSA before this happened? I mean, before the proposed rulemaking on the cost benefit?
Always with rules, we review the proposed rules before they go out.
Thank you. My next question is on billion-dollar cost to the economy on rulemaking. I know you were asked by Speaker Boehner and some other House members last year to tell them how many billion-dollar rules the administration is preparing, and they didn't receive any answers, to my knowledge. which has caused a lot of uncertainty in the business community. I know Mr. Weiner says everybody's doing wonderful, but the reason they've got that cash sitting aside is because they're afraid to invest it, not knowing what regulations are going to come down the pipe. So, you know, do you have an answer today? Can you tell us how many billion-dollar rules that you're planning?
I can tell you how many $1 billion we've done, and it's a very small number. Planning, as our discussion suggests thus far, requires the process of interagency review, public review, efforts at cost reduction. So the number of rules that are planned in any strong sense that cost over $1 billion is very hard to specify. Often there are rules that are under discussion, but they're not really planned, and they might come in like a lion and go out like a lamb.
Well, perhaps we can get back with you on that later and after a couple months or so.
Yeah.
The other thing that I wanted to ask is when you look back on the regulations that have been issued during the administration, can you identify any in which it has been determined that the benefits have not justified the cost? Do you have that kind of analysis that you could share with us?
Yes. There's only one big one that comes to mind. It's called positive train control, and it's a statutory requirement. And the Department of Transportation had to issue it as a matter of law, even though the monetizable benefits are lower than the monetizable costs. There aren't a lot like that.
Would you be willing to submit again for the record?
Unquestionably.
I would appreciate just the full answer and the explanation on that particular situation. With that, I do yield back the rest of my time, Mr. Chairman.
I thank the gentlelady. The gentleman from Massachusetts, Mr. Markey, is recognized.
Thank you, Mr. Chairman, very much. So we all know what the reality of this hearing is. The Republicans hope that they can use the Regulatory Flexibility Act to turn the United States into a health, environment, safety, and consumer protection regulation-free zone. And the presumption is that regulation is bad, but obviously that's not necessarily the case. For example, we've heard a lot about how EPA's efforts to regulate global warming pollution will lead to an economic catastrophe, but this is just not borne out by the facts. Before the Obama administration's global warming regulation for cars and SUVs were announced in 2009, the auto industry in this country was literally in the tank before the regulations were, in fact, promulgated. More than 300,000 jobs lost, 2 American companies in bankruptcy, and consumers no longer willing to buy the gas guzzlers that the domestic automakers had bet the bank on. And what has happened since the regulations were announced? Well, in 2010, auto sales went into overdrive and soared more than 11%, snapping the industry out of its 4-year decline. Companies were rehiring thousands of workers, and there has been a proliferation of new companies that plan to make and market electric vehicles and other advanced vehicles. So this Groundhog Day recitation of how regulations will destroy the economy and jobs has already been shown to be flat out wrong. So I have some questions about EPA's future global warming regulations that perhaps you could help me with, Mr. Sunstein. Will regulations that seek to limit global warming pollution from power plants or refineries also take into account the increase in jobs that could result from the development and installation of new clean energy technologies?
Yes.
Yes. Isn't it true that regulations to curb dangerous air pollutants could result in quantifiable cost savings in the form of medical expenses that won't be incurred or environmental damages that won't need to be mitigated?
Yes.
Installing pollution control technologies on power plants could also lead to increases in the efficiency of the facilities and significant cost savings for companies. Will you be quantifying these and other benefits as part of any regulatory analysis?
These are not multiple choice questions, and the answer is yes.
Thank you. The EPA recently announced that it would only issue its proposal to regulate global warming pollution from refineries and power plants after meeting with business leaders and other stakeholders to solicit their input. Is this consistent with the President's executive order requiring agencies to seek the views of those who might be impacted by regulations before proposing them?
Under Section 2, absolutely.
EPA has also issued a rule that ensures that millions of smaller sources of global warming pollution are exempted from a requirement to obtain Clean Air Act permits, and that the requirements for medium and larger emitters would be phased in over a period of several years. Is this consistent with the President's requirement that regulations take the special needs of small businesses into account?
Yes.
Are EPA's actions also consistent with the President's executive order requiring agencies to promulgate regulations that impose the least burden on society and maximizing the net benefits to society?
That was the goal of the PSD tailoring rule.
Thank you. EPA recently proposed a rule to regulate air emissions from cement kilns. In its analysis, EPA found that the health benefits of the rule would yield between $7 and $18 for every $1 in costs. Do you think that this sort of return on a regulatory investment is a good one?
Sounds like it would be a very good investment.
Historically speaking, have industries typically overestimated the costs of new regulations?
That is frequently the case.
Now, for the cement kiln rule, EPA didn't even consider the benefits of reducing emissions of hazardous substances like lead, chromium, or arsenic. Historically speaking, have agencies typically underestimated the benefits of new regulations?
Often they have. We need to be very systematic to answer the question typically.
I thank you for that precision in your answer, but I think the larger point is true, that our lives are longer and safer and better because of a regulatory scheme that began to be put in place in 1900. Average age of death in the United States in 1900 was 48 years of age. These regulations that have gone on the books from the Garden of Eden until 1900, 48 years of age, now it's 79 years of age, 31 bonus years. Something happened in the last 100 years, and we exported it around the world that we got all those extra years, and a lot of it is protecting the health, the safety, the environment, and ensuring that those regulations are there to protect everyone, not just the wealthy, which is what the first 5,000 years of humanity was really focused on. I thank the gentleman.
I thank the gentleman. The gentleman is very active and interested in baseball, and in this case he's offered Mr. Sunstein a lot of softball questions for you. So, Mr. Gingrey.
Thank you, Mr. Chairman. Mr. Sunstein, obviously it would appear on the Democratic side of the aisle that all regulations and regulatory regimes are good, and they're suggesting that on our side of the aisle they're all bad. But obviously it's somewhere in between. And really the purpose of this hearing and your testimony, we want to glean the truth, because clearly some regulatory rules are bad. And in regard to the issue of human dignity and consumer protection, let me reference last year the administration included an end-of-life Medicare payment rate for physician services in its final rule at literally the last minute, without allowing for a period of public comment. Only after a large public outcry did the administration own up to its actions and indeed reversed itself. Section 1 of the President's recent executive order states that our regulatory system, and I quote, must allow for public participation and an open exchange of ideas. I want a yes or no answer. In your opinion, did the administration allow for public participation in the crafting of this regulation as spelled out in Section 1 of the executive order? Yes or no?
As the repeal of the original rule suggests, the judgment of HHS was that there had not been an adequate opportunity for public.
So the answer is no.
Yeah.
Yeah, thank you. Another yes or no question. Do you or OMB know who in the administration made that decision to not allow public participation, instead slip this regulation into the rule in the dark of night? Yes or no?
I don't personally know.
Okay. Another yes or no. Do you know which individuals within the administration would have the authority to slip a regulation into a final rule in the dark of night without allowing for this public comment?
I don't think anyone has that authority.
So the answer is?
No, I don't know. I mean, there are people, the Secretary of HHS has considerable authority over her rules, and she does not slip things in the dark of night.
Well, it certainly does appear that the administration purposely avoided obtaining congressional approval for an unpopular regulation that they could not sell to the American people last Congress. So instead, the measure was inserted into this morass of regulations in the hope that no one would notice. Do you believe that the American people deserve to know why they were not allowed to publicly view this regulation before the administration published it? Yes or no?
I think the American people deserve to see the content of rules before they are finalized.
So the answer is yes.
That's in the executive.
Thank you. Again, would this recent executive order 13563 prevent the administration from enforcing a regulation without allowing public participation in the future?
That is correct.
Can you assure us here today, Mr. Sunstein, that this administration will not attempt such an illegal end run in the future, yes or no?
Yes.
Thank you. And finally, and I'll yield back some time, Mr. Chairman.
I thank the gentleman.
The witness would answer this last question. Would you agree this shows how regulations can make unpopular actions possible without Congress having to support political risky positions? Yes or no?
Well, if I have to answer yes or no, I'd answer yes to that one.
Thank you. You've been a great witness, and I'll yield back to the chairman.
I thank the gentleman, and now we'll move on to Mr. Scalise, who's recognized for 5 minutes.
Thank you, Mr. Chairman, and Mr. Sunstein. Appreciate you coming before the committee. I want to start asking about regulations regarding oil and gas drilling operations. And I think you touched on some of that, but does OMB actually go and review the rules from the Department of Interior concerning oil and gas regulations?
If they are significant regulatory actions, yes. So it depends on their nature, but some of them, the answer is yes.
Okay, some of them. When the Department of Interior came out with the moratorium on drilling, did you review that?
No, that wasn't a regulatory action within the meaning of Executive Order 12866, so we did not review the moratorium.
At least that's your feeling that it wasn't?
No, it's just it doesn't fit easily within the definition of a significant regulatory action.
Why would you not think that would be significant, the president literally shutting down an entire industry, which has a cost of billions of dollars?
I completely understand and appreciate the question. The answer is somewhat technical, which is the foundation for our authority is rules within the meaning of the Administrative Procedure Act. Moratorium isn't a rule within the meaning of the Administrative Procedure Act. We do extend review somewhat beyond that to significant guidance.
When you look at, well, I'll just bring you back to President Clinton's Executive Order 12866, which is still in effect and part of your department's purview. If it has an annual effect on the economy of $100 million or more, or more adversely affects in a material way. I mean, we're talking about a major policy decision that had an impact of well over $100 million, and in fact is one of the reasons that we're seeing the price of oil approach $100 a barrel. Would you consider that, first of all, a major economic impact of $100 million
yes,
more?
though the it, which is the referent, is to regulatory actions, as I mentioned, and that's a term of art under the executive order. The moratorium didn't quite fit under that.
Yeah, I'd reference you to also go back and look at the federal judge's ruling who felt that the department did go outside of their purview.
That's correct.
In issuing that, and I'd be curious to see what your relationship with those reviews was, and I'd be surprised if you didn't feel that it was something that your department should have had review over. As it relates to the current regulatory scheme, are you in review of those rules?
Yes, anything that counts as a rule under the Administrative Procedure Act, absolutely. Significant guidance documents and interpretive statements under a March 2009 memorandum by the Director of OMB, we review those also.
Is it true that the department did not perform a regulatory flexibility analysis regarding its impact on small businesses?
I don't recall the answer to that one. What are you?
I'll help you.
With the moratorium?
This is from OMB. This is an OMB document that actually says that the oil and gas operations on the Outer Continental Shelf, the actions that they took did not require, according to your office, did not require a flexibility analysis.
Are you referring to the moratorium, or are you referring to a rule?
They're increased safety measures as they referred to them.
Ah, okay. Well, if it's a rule, then there has to be an analysis to that effect, and that my recollection is that the small business impact were not significant enough to require that analysis.
And who's that based on?
That's based in the first instance under the Regulatory Flexibility Act on the judgment of the relevant department.
So you just take their word for it. If they say it won't have a $100 million impact, clearly, and I'll just run you off some numbers that the White House has actually confirmed. It's cost up to 12,000 jobs that our economy's lost because of that action.
Okay.
It's cost about 12% of our current U.S. oil production and about $70 billion of investment, which is, there have been a number of private research that's been done to show that that's had that kind of $70 billion. So you just took their word that it wouldn't cost over $100 million?
And okay, if you're referring to the moratorium, as I say, that's not subject to our review under our executive order. If you're referring to some rules that we've had,
they're overall rules.
Well, the moratorium is distinct from the rules. I don't believe, though I might be wrong on this, that the rules are anticipated to have significant adverse job impacts. One of them is,
well, it already has. I mean, that's been documented by the White House.
The rules.
So when you come out with your flexibility analysis and you determine, or you take their word that they don't need to do one under the law.
I said in the first instance, which is a very important qualification, we do not take their word as authoritative. And we engage with the Office of Advocacy and the Small Business Administration very carefully.
All right, and I'd like to get any kind of documentation, emails, correspondence that you had with them in relation to these rules and in the determination not to do a flexibility analysis by your department, because that was a ruling that your department made.
I believe you're referring, though I'm not sure, to the moratorium, which, as I say, we didn't review. If you're referring to the rules, then we did review at least two.
And did you review the...
With full analysis of costs and benefits.
Did you review the 30-day safety report that the President's own scientific commission, because one of your challenges or your tasks is to base this on science, and his scientists actually said it would reduce safety in the Gulf. The scientists said it would reduce safety in the Gulf to impose the moratorium. That was in the 30-day safety report that came out.
The 30-day safety report isn't a regulatory action subject to formal OIRA review.
Right, but it was doctored by, from every report we've gotten from the climate czar, who's conveniently leaving, but that document was doctored to imply that the scientists said that the science backed it up, when in fact the scientists said it actually would reduce safety to impose that, and that's what the Department of Interior used as the basis. So do you look at any underlying documents? If a department says we're going to make a rule and we're going to base it on underlying documents, do you look at those underlying documents?
I was about to say I'm very grateful that's not a yes or no question, but it ended up being a yes or no question. If it's not a regulatory action, then we don't have formal review, though there may be some participation by some of OIRA staff. Our lane is the lane of regulatory action, with the central feature being rules. Reports of that sort, we may have some informal.
And I know I'm out of time, but the regulatory actions are costing jobs in the thousands right now. That's something we'll have to follow up on.
That is so appreciated, and at the core of the Small Business Memorandum and the executive order is insistent focus on job creation.
Mr. Garner, Mr. Scalise asked for some documents. I think you might provide him, had his request, some of those things. Mr. Gardner is recognized for 5 minutes.
Yeah, thank you, Mr. Chairman, and thank you, Mr. Sunstein, again for your testimony before this committee. I just want to talk a little bit about how something is reviewed under these executive orders, and hoping to have you help me understand what takes place. Could you explain briefly how your office would review a regulation under Executive Order 12866, and what are the key components of your review?
Okay, thank you for that. What we would do first is explore with other agencies which are going to see the rule, whether the requirement of consideration of alternatives has been met, whether the agency has done a careful analysis of costs and benefits, whether the agency has justified its reasoned determination that the benefits justify the costs, whether the agency has shown that there's a compelling reason for federal action, whether the agency has considered reliance on the market, reliance on state authority, as some of the earlier questions suggested.
So it's safe to say that that there's basically three core components where you identify and assess available alternatives to direct regulation, dealing with alternative forms of regulation, and then of course getting to impose the least burden on society, including individuals and businesses?
Yes, and we recently issued a checklist that basically puts in a page and a half our essential inquiries.
So if you take a real-world example of the EPA and greenhouse gas regulations, how did your office use those requirements when carrying out that rule review?
Well, the most costly of the greenhouse gas rules is the one that there's very considerable enthusiasm for, which is the fuel economy rule. And what we did for that one was to investigate the costs of the rule, the benefits of the rule, to think of what alternatives there are in terms of stringency, to consider what kind of flexibilities might be provided for small business and others, to ensure that there was full public participation so that people could comment on the options, and to try to come up with the approach that maximizes net benefits.
And 12866 also says that the underlying analysis of cost and benefits of potentially effective and reasonably feasible alternatives to the planned regulation identified by the agencies or the public, and it goes on to say, and an explanation why the planned regulatory action is preferable to the identified potential alternatives. Did the EPA provide and did you review an analysis of the reasonably feasible alternatives for the endangerment finding and the subsequent greenhouse gas regulation?
Yes, that's laid out in great detail in the regulatory impact analysis, and it's also in the preamble to the rule.
And what alternatives then did the EPA provide to you?
The EPA and the NHTSA discussed different levels of stringency and explained that a more stringent approach would run into serious concerns about feasibility and cost.
And that was your evaluation of each as well?
We concurred with the evaluation. We thought it was a very reasonable evaluation.
The testimony that we've heard today from members of the committee as well as our colleagues on the other side of the aisle seem to, as the gentleman from Georgia stated, be an extreme to the left or the right. What am I supposed to tell my constituents when it comes to those who come to me and say, these regulations are costing me jobs? I mean, are they wrong? Are they wrong that this is costing them a job? Do they not know what they're talking about?
Well, we need to know what regulation it is. But I think the first thing you should say to them, it was reflected in your opening remarks, is that there are two sets of concerns. One is about fear of what's coming, and the other is trouble caused by what's there. On fear of what's coming, you have a very strong signal from the President of the United States with respect to small business in particular. And that's a document.
So they're just fearful?
Well, no, that's not all. I'm using your words. And that's a legitimate fear that regulation can be harmful. So when you ask what should you say to your constituents, I think you can say that both that your subcommittee is on this issue and the President of the United States and the Administrator of the Office of Information and Regulatory Affairs share this concern. And with respect to fear of what's coming, we want to work directly with you to make sure things are going right rather than wrong.
So will you then make the commitment?
Say with respect to the current regulations, I'm very glad you introduced that because the President has called for a look back at existing regulations that cause trouble. And you can find things in the very recent past where agencies actually have looked back, including the EPA.
Who triggers the look back? Who does that?
The look back is a process that the Office of Information and Regulatory Affairs is helping to coordinate.
So you will request the look back of the agency?
Well, the President has requested the look back.
But you will request to the agency, the regulatory agency, what rule to review?
They have to submit plans to us within 120 days, and we'll work closely with them to figure out what the...
But looking back, you will request those rules going back, already in effect?
We will be participants in the process of figuring out what to look back on. I hope you will be a participant also.
Will you make a commitment today, then, during this time of economic crisis, that you will use your power to make sure that regulations, the administration doesn't put its stamp of approval on any regulation that costs American jobs?
Well, what I would say is if there's...
That could be a yes or no question pretty easily.
A yes answer would be preposterous. If there's a regulation that's saving 10,000 lives and costing one job, it's worth it. But what I would make a commitment to do is to focus every day on job creation and the urgent need, as the President emphasized last night, to square everything we're doing with the overriding imperative of promoting competitiveness, economic growth, and making people get good jobs.
Thank you, Mr. Simpson.
Recognize Mr. Griffin.
Thank you, Mr. Chairman. If I might follow up on that question and ask you, are you all taking a look at when you're looking at that job loss, are you taking a look at the benefit not only in this country but the cost of sending those jobs overseas? I mean, one of the things that we worry about in my district when people are talking to me about regulations are this product is going to be made and sold in the United States. The question is whether or not it's made in the United States or whether or not it's made in China or some other country where they don't have these regulations. And so when you are looking at this, my question to you is, are you looking at what other nations are doing? Because if we're having a small benefit, but we're sending the jobs overseas and we're still going to get the product, but now instead of having the jobs, we've gotten a small benefit and no jobs. And do you all take that into account when you're looking at these regulations, and particularly the EPA?
Yes, we had in our 2010 report to you all, our annual report to Congress, a detailed discussion of the risk of job loss from regulation that might send jobs overseas. And we are continue to be very focused on that risk.
Well, I understand that, but are you marrying the two concepts? Okay, we're worried about sending jobs overseas, but are you also looking at what is the net benefit to the United States? And then are we looking at what is the net benefit in the world environment? Because if the benefit is that we're going to clean up the air a little bit, but we're sending all the jobs to China where they won't even have the regulations we currently have, aren't we in effect, if we aren't marrying those two? So question number one of this would be, are we marrying them? And number two is, are we in effect making the environment of the world worse in many ways if we send these jobs offshore where they won't follow the same rules that we have?
It's a great question. It's a fabulous question that, and it's been raised in the context of some rules where it may be that the environment, the world environment, is actually worse off as a result of what we do. Our basic source of what we should consider and lay out is legal requirements. So it may be that some of the environmental harms done elsewhere in the world aren't really legally relevant. They're not part of the statutory apparatus under which we're operating. But, and thank you for letting me elaborate a bit on this, but if you'd asked me a yes or no question, I would have said with slight embarrassment because it's too simple, but I would have said yes.
All right. And let me ask this because it's just been troubling me, and you've heard these questions before from some of the other members about the EPA. A spokesman has said that they don't think that this will affect them in essence. And I guess, and you have made it very clear that, yes, the President's executive order does apply and that you all are looking at those regulations as well, but clearly somehow they got the word they didn't. Do you know of whether or not there was a private get-out-of-jail-free card or a wink and a nod that would say that they don't have to, we're going to come look, but don't worry, everything's going to be okay?
I'm confident there was no wink or nod or side conversation.
All right, I yield the rest of my time back, Mr. Chairman.
I thank the gentleman. Mr. Terry is recognized for 5 minutes.
Thank you, Mr. Chairman. I appreciate you being here today. It has been helpful. First of all, I want to comment a couple of things from 3 of my colleagues on the other side. Do you believe that this side of the aisle are regulatory anarchists and want toxic materials thrown into rivers? And
if I may say, I think the questions, you know,
right.
It's an honor to talk with any of you about these things, and the questions have been excellent, and you deserve an answer. So I see no evidence of...
And you have done well in that area. Let me follow up one question from Mr. Markey. Do you think they're banning all use of fossil fuels would yield positive health for human beings?
All things considered, no.
What do you mean by all things considered? I mean,
well,
just would it be healthier if for our people if there was no fossil fuels used?
On one dimension, it would be healthier because the pollution would go down, but the economic hardship would be
and the balance
healthy.
is the issue here.
That's
so
right.
we can't deal in extremes is my point here.
That's right.
cost-benefit analysis is appropriate. And the President's executive order, 13563, includes a cost-benefit analysis, correct?
Yes.
And you testified at the beginning that his executive order does not apply to independent agencies.
That's correct. Following President Reagan's lead, really.
Well, yeah, it doesn't. So the FCC, I'm chairman of the vice chairman of the Communications and Technology, so my focus is with the FCC. So the executive order does not apply to the FCC.
It does not.
All right.
I might add that the small business memorandum, the president which requests that the independent agencies comply with.
And has the FCC said they will comply to that order?
We have not heard.
Okay. And in that regard, we've talked about, or you mentioned, that the executive order would help the administration reach that cost-benefit analysis where you weigh both sides. And so do you feel that as you sit here today in your position, not as a law review author, but in your capacity today, that would be beneficial for the administration if the executive order would apply to the independent agencies?
I believe that cost-benefit analysis is a helpful tool for any government actor. And in that sense, I believe that its use by the independent agencies would be informative.
Would it be helpful to you in determining whether to give advice and counsel from OMB on behalf of the administration to those agencies?
I think we're very respectful of the independence of the Federal Reserve, the FCC, the FTC, which have independence as a matter of legal authority. It would be helpful to us, I'll tell you, in one domain that's exceedingly important, though slightly technical. We provide annual reports to you all on the costs and benefits of regulation. You have asked us to provide information on the costs and benefits of regulations by the FCC, the FTC, all of the independents. More often than not, we don't have anything to tell you because there isn't a cost-benefit analysis. And
I would appreciate that. Is there a separation of powers or constitutional issue here, in your view?
There is certainly an issue in the sense that the President's legal authority over the independent agencies has occupied many less than fascinating pages of law reviews.
But can that be resolved by congressional action, or is there still, in your opinion,
you could resolve
Harvard?
That.
I know you're not a Nebraska graduate, so we have to question your academic history. But nonetheless, in your esteemed opinion.
Yes, I think professors at the University of Nebraska would agree that whether the independent agencies are subject to presidential control is ultimately up to Congress.
So the congressional authority would be necessary, and is that something that the President would request of us?
I'm not aware that the President has a view on that issue.
All right. And the independent agencies still have to provide regulatory plans.
That's correct.
Did the FCC provide you a regulatory plan that included net neutrality in 2010?
I believe so. I know they provided a plan, but I don't recall its exact ingredients.
Okay. My time is... Would you submit that for the record?
Delighted.
Thank you.
This time has expired, and the gentleman from California, Mr. Bilberry.
Thank you. Mr. Sunstein, last night the President proposed building a high-speed rail system in America that would cover 80% of the people and do it within 25 years. Do you believe under existing regulatory realities that that is possible?
As I noted, the Oira lane is narrow. We review existing regulations, so that's beyond my authority and my knowledge base.
Okay. Let me just say, as somebody who's built a rail system, I think that's where you need to, people like yourself need to be able to address that issue. When a president proposes something, and it's not just money, it's is it legal to do it? And as somebody who's built a rail system, my opinion of somebody who's actually done it is that no, it is not legally possible under existing regulatory legal structure to build the system that the president proposed, which places all of us in the challenge of do we not only talk about how much it spends, but how much regulatory reform we need to make it possible. Do you have any experience in implementing projects such as transit, such as sanitation, such as building a factory? Do you have any experience in going through the regulatory process as a participant of that process?
Any citizen has at least some experience in navigating the regulatory process, but my own experience with the regulatory process has been a participant over the last 2 years in making sure that the burdens to which you refer are as streamlined and navigable as possible. And the most important part of my experience in that domain, something that hasn't gotten much publicity, I hope it's an answer to your question, is that we quietly asked every agency of the federal government, including the independent agencies, for burden reduction.
No, whoa. See, you're asking about the process, and you're doing it as as a regulatory member. I'm asking you, though, have you been the applicant? Have you personally been through the gauntlet, or have you observed it from an administrative point of view?
Does my dad count? My dad had a small construction company.
No, your dad doesn't count. We don't allow a crime of blood or benefits of blood on this issue.
My own career has not been navigating regulatory processes, but I'm trying to make them easier for people who do.
As somebody who's been on both sides, this is where I see a real problem of if you haven't walked the mile, if you haven't gone through the frustration, if you haven't seen the obstructionism, you really don't understand how to correct the problem appropriately. And I think you and I would agree, if the plumbing in your house was backed up, you would not call a doctor or a lawyer to address that issue. And the fact is, I'd ask you a question. Let me back off and say this. Do you believe there are environmental laws on the books today that are hurting the environment with their enforcement?
Well, I do believe there are environmental laws on the books today that can be significantly improved from both the economic and environmental standpoint.
My question is, do you believe that there are environmental regs on the books today that their enforcement is actually hurting the environment rather than helping it?
It would be most surprising if the answer weren't yes, for at least some.
Okay. Then my question to you is that when we get into these review of assuming that the law's intention is actually being fulfilled, wouldn't you agree that that is a wrong assumption to make from the get-go? That law's intentions are assumed to be effective rather than questioning are they effective, so that there's a burden of proof of existence of those laws need to consistently be tested for their effectiveness and efficiency?
Well, the President gave a clear yes answer in the executive order, which said we need to measure the actual results of regulations, and the look back is intended to do that.
Okay. Do you know what the reductions per vehicle was projected with the new environmental regs on auto manufacturers?
The reduction per vehicle, I don't have the number. The reduction of emissions per vehicle?
Yeah. What was the goal with that reg? Yeah, it's a pretty big reg. We ought to know what the number was.
Per vehicle? I know that the number is...
The fleet, okay, I'll give you per vehicle or fleet reduction.
Well, the emission reduction?
Yes.
I don't have the exact number.
I just asked him per percentage.
The goal is about 36.5 miles per gallon.
And what percentage is that a reduction they're looking at?
We'd have to do a little arithmetic to get it right.
Okay. What if I told you that scientists are already telling us that we can reduce emissions and auto emissions by 22.6%, and Washington has done nothing to consider that cost-effective program while it is putting burdens on the production of automobiles in this country?
If I may ask, what's the cost-effective program
The cost-effective program is for us to go back and look at traffic control operated by government that is inappropriate.
We are interested in any method that's cost-effective, cost-justified to make this situation.
Wouldn't that be a kind of savings that we need to do more of with our cost-effective analysis?
It sounds like something very much worth investigating, yes.
Thank you, gentlemen. And I ask unanimous consent to let Mr. McKinley ask question. He's on the full committee, but he's not on the subcommittee. Without objection, so ordered. Mr. Kinley, thank you for taking the time to come down, and you're recognized for 5 minutes.
Thank you, Mr. Chairman. Thank you for being here. I've got just a series of questions, more specific, and they deal with the spruce mine in West Virginia. You're familiar with that?
That's not something.
Can you give me some volume, please?
Okay, sorry. That's not something within our purview. We review regulations and regulatory actions. I believe what you're pointing to isn't something that's within the domain of the Office of Information and Regulatory Affairs.
Yeah, EPA. Yeah. But this was a retroactive veto. Are you aware of that?
I have a recollection from newspaper accounts, but this isn't something within our authority. We do look at rules that have effects in this area, but what you're referring to, I don't believe is a regulatory action under Executive Order 12866.
Were you aware of this veto prior to it happening?
No.
You were not aware?
No.
Do you have any idea why the EPA came to that decision?
This is something which it would be good to engage the people who made the decision for their explanation.
Were you aware that the EPA has made this determination to do it retroactive based on some new science?
Because this wasn't regulatory action under 12866, if I'm following, this wasn't something that we saw in advance in any way.
Do you think that that's something that they should have checked with you about before they embarked on something that was so draconian to West Virginia?
Well, one thing I will say, which is that in the regulatory domain, anything that's draconian for West Virginia or anything else is of keen concern to us. But that thing had better be, under the new executive order as under the old, a regulatory action within the meaning of both documents. And so I wouldn't want to comment on the decision or the process, because my understanding is that this was not something that is subject to our review.
But you have enough awareness of it, so now I'm just the last question has more to do with, is it possible that if the regulatory bodies think that they can do this retroactively to a specific site in West Virginia, this is only in the Appalachian District, they're doing this in the mines, and they've applied it the first application has been in the mines in West Virginia. If they feel they have the jurisdiction to be able to do that, could they not also do that in other markets, like, for example, the chemical industry?
What I would say in our domain is that rulemaking is not retroactive. Actually, the Supreme Court has said that rulemaking is presumed not to be legitimately retroactive, and that under the President's new executive order, not only are rules not retroactive, but they also must be preceded by a period of public comment, so stakeholders can see it. Not only that, the agency is supposed to engage stakeholders, including those who would be adversely affected, before they even propose a rule. So that's our policy with respect to rulemaking.
Was this Do you think that this was a violation then, if they've made this retroactive?
Well, as I say, this is not our lane or our area, so I wouldn't want to speak to it absent authority or a full account.
Do you think that if they again, the last question I had was, if rulemaking can occur like this in a retroactive fashion, directed to the coal industry, would it not also apply to petroleum, chemical, other industries as well?
The Supreme Court said in a decision a few years ago, retroactivity is disfavored. And to answer that question, I want to know what exactly was the situation here and whether there was something unique to it that justified the action. And
from what I understand, sir, there was new science introduced, but that new science was funded by the EPA. The study was funded by the EPA. I don't know whether that would, I'm an engineer. I don't know that would necessarily, if I fund something, whether that's new science.
Well,
that's bolstering my cause.
I greatly appreciate the question, and with your indulgence, I'd want to stay away from an area that I don't have authority over and that I haven't studied. I would say that with respect to the scientific issue generally, under Section 5 of the new executive order, there is a strong emphasis on objective science and scientific integrity, and that's something in the rulemaking area, which is our domain, that we are taking exceedingly seriously.
Since you've heard of this now, are you going to look into it?
If you'd like me to, I'd be delighted.
I would love to have you look into it.
Have you put in contact with the people who have
I'd like to know more about what the repercussions of this are.
Sure.
Thank you very much.
And thanks to you.
I thank the gentleman. We're going to go a second round of questions.
Great.
Ask for your help here. Just a few more, and then I think we have votes at 1:30. Say again?
Are you going to ask me yes or no questions, Mr. Chairman?
I try. You know, there's something here I want to ask you. It's a basic question. How many new government regulations have been enacted since your appointment?
I believe the number of final regulations is going to be approximate.
No, I know.
It's about 500.
500. Okay. And do you perhaps have any idea how many new regulations will be necessary because of the new health care bill and because of the new financial service bill?
I don't have that number. I would say that our number
If you can venture a guess, that would be really fine.
I wouldn't want to venture a guess because there's a fact of the matter, and one doesn't want to guess about things when the fact of the matter is not difficult to find.
I'm just being a little humorous. I'll give you a range. Over 5,000 for health care?
It would surprise me if it's that high.
Okay. And over 5,000 for the financial bill?
It would surprise me if it is that high.
Okay. Earlier, and I asked you this question, and you said yes. The director of OMB produced a set of recommendations for a new executive order within 100 days of the President's January 30th, 2009 directive. That means the OMB recommendations were sent to the President around May 2009. I thought you said yes. And is that correct? Is that yes, your answer still?
Yes.
But the new executive order wasn't issued until January 18th, 2011. I had staff check that out after the elections. So your yes doesn't seem to comply with the facts.
Okay. No, what the President asked for in his memorandum, to which you point, the early one, was not a new executive order for issuance. It was recommendations for a new executive order. And what we did was to run processes for a significant period under the Clinton executive order, under which President Bush also operated, and acquired experience. We had a public comment period. We got a lot of comments from affected stakeholders, some from members of Congress. There were informal and formal communications. And the process of acquiring information, learning from the agencies and from our own processes what works well and what doesn't, ran its course such that we were able to issue the executive order last week.
Okay. In your testimony today, several times you mentioned the word retrospective. Review will be done of regulations. I guess the question is, it hasn't been defined in my mind. When does that begin? Does it include regulations issued during the Obama administration? Are you going back to the Bush administration? You're going back to Clinton administration? Maybe you might define what retrospective means.
The executive order says significant regulations that are on the books, so everything is fair game.
How far does that go back? In your mind?
It could go back to the 1920s if there's a
Okay.
regulation that's costly and not helping people.
So you could go back to FDR.
It certainly could go back to FDR. And
Okay.
everything is fair game. Needless to say, regulations that have been issued within the last weeks and months wouldn't be the first candidates for retrospective review because they were reviewed very recently. But we are eager to get ideas from you, Mr. Chairman, affected stakeholders, members of the public. We really need your help to identify regulations that should be revisited. And if they're doing harm, but they're from 1945, then by all means, let's revisit it as much as we would if it's doing harm as 1982.
I commend you. You're the first person from the administration I've ever heard that said they're willing to go back and look at regulations from the FDR. So that's quite a statement. Now, will these review apply equally to all the agencies or just certain agencies that you're focusing on? I imagine that all the agencies would be a mammoth job.
As you said, the independent agencies following President Reagan's lead are not covered, but all the executive agencies are covered.
In you promulgating vehicle fuel efficiency standards, did the agency consider the cost of additional injuries and deaths stemming from the use of lighter vehicles?
Yes, that was investigated with great care.
When you talk about this retrospective, how are you proposing to bring in the public? Like the gentleman from West Virginia indicated that here we had a company, they got approval for a license, and then retrospectively EPA stopped his license. Now the company's in jeopardy after investing millions of dollars, and employees will lose their job. Who would think that that could happen after the government given a license? How are you getting to the public to interface with you?
Yeah, it's a tremendous question, and we love your ideas. I'll give you a few preliminary thoughts. One idea we've had is that the public has a lot more information than we do about what rules are actually doing on the ground.
I agree with that.
So we need their help. It's happened already in this very early time that we've gotten a lot of communication from the public. The public has not been silent about rules that are causing trouble. I think you can expect in the relatively near future one very important cabinet agency going out to the public and asking for ideas about retrospective analysis, what rules are causing trouble. I think you can also expect a high degree of openness, both with respect to asking for ideas about rules that no longer warrant public approval, and also for ventilation of the plans, which are due, mind you, in 120 days. I'd love it if some of those plans would beat that deadline and be out to the public before 120 days. But my expectation is that the plans, which will include candidates, will be made public, and there will be a period of comment. And as Chairman Diggle suggested, there's a full process of comment and review as rules get repealed. So that will also involve a high degree of public participation.
Thank you. My time has expired. Dr. Burgess, second round.
Thank you, Mr. Chairman. In reference to Dr. Gingry's question about the regulation that went forward without a period of public comment, are you aware that there are, in fact, at least 10 such regulations under the health care law, under the Patient Protection and Affordable Care Act, at least 10 such rules that were created without a period of public comment?
Yes, what I'm aware of is that some laws, and this is one of them, have for some rules time constraints that are so severe that the only option is to do what's called an interim final rule rather than go out for public comment, and that's a result of legal compulsion. What's noteworthy about interim final rules, and we've paid a great deal of attention to this, is they are interim final rules.
Well, you offered just a moment ago that you would follow up with us. I actually look forward to you joining us again in about 3 months' time. If you would be willing to do that, maybe we can talk about some of the public comment that's come in on some of the interim final rules, because it is important that this process be open and transparent and that people be able to communicate with the regulatory agencies in their government. I know I've heard from a lot of providers, hospitals, and patients that this is something that they would like to see.
Yes, absolutely. I spend a lot of my own time, it's sad but true, on regulations.gov, where you can see those comments on interim final rules, and I'm quite aware that some rules have produced a lot of public interest.
I provided to you a apologize that it wasn't in the briefing binder, but something prepared by the Business Council, the Business Roundtable, policy burdens inhibiting economic growth. Did you have a chance to just glance at that while we were at the vote?
I did glance at it.
And I appreciate you being willing to do that. Of course, our purpose here today is to talk about the regulatory burden and what we might do. This paper was prepared, interestingly enough, last June at the request of the Obama administration. Difficulty in this economic climate creating jobs, and the Obama administration asked the private sector provide us some guidance on what the Obama administration might do to facilitate job creation. So I think that was a good idea. The question I have is why are we ignoring some of the more important things that were put forward in that monograph? We have, and I referenced this in my opening statement, the new source review aspect that was talked about in that paper was concerned about the fact that Texas does seem to be singled out for some special attention on taking its flexible permitting process, and that other states that are using this were not subjected to the same constraints that Texas has been. Do you think this is helpful in creating a climate for job creation, that Texas be singled out in this way?
I should say that the document to which you point has a lot of concerns, and that has been reviewed carefully by relevant officials trying to make sure we do the best we can for the country. Singling out any state, in some ways Texas in particular, is not a good idea. Everyone should be treated similarly. What I would say about the particular example, I'll give you my understanding, is that 49 states all complied with the EPA's permitting rule, in the sense that there was, Texas didn't.
My time is pretty limited. Let me just ask you a more specific question.
This was an effort to help people in Texas get permits. In order to go forward, there had to be some permitting process, and the court approved it.
That was under the greenhouse gas requirement, but did anyone at EPA consult with the Office of Management of the Budget or the White House before moving forward with taking over the flexible permitting program under the Clean Air Act?
That one was something that we were involved in, yes. And this was an effort, as I say, to permit people to get permits in Texas so they could go forward with construction, et cetera. That's my understanding.
And what is the status of that today?
The court has approved it.
Let me ask you a question that's in a different direction. Do you think there should be any legislative effort to regulate broadcasting in the interest of democratic principles?
What I would say is that as the administrator of the Office of Information and Regulatory Affairs, I'm focused on the Paperwork Reduction Act and on the recent executive order and small business memorandum. I think you might be referring to some academic writing that might have had my name attached to it, but academic speculations by anyone, including yours truly, just aren't relevant to the current job.
But still, there is some talk about people who want to bring back the fairness doctrine, and some people do see that as a restriction on free speech. Would that be something that would come through your regulatory agency if that occurred?
No, we have no role, and I'm on record as opposing the fairness doctrine.
Right. Thank you, Mr. Chairman. I'll yield back.
Gentlemen, Mr. Griffin, you're recognized for 5 minutes.
Thank you, Mr. Chairman. If I could go back to some of Congressman McKinley's questions related to the mine closure in West Virginia. And I know that what actually may have happened may not be under your watch, but wouldn't it be true under the executive order that you would need to look at that? Because as I understood the President's comments last night in regard to the salmon, that one of the things that he wants to do is to make sure we don't have agencies having jurisdiction over what most people would think would be the same thing. And in that particular case, would you not agree with me that it didn't meet the circumstances, the facts didn't meet what the President has said even in his Section 1 of his executive order, because for that mine it didn't promote predictability and reduce uncertainty. It created more uncertainty for everybody in Central Appalachia because of that ruling. Would you not agree?
I appreciate the question. I'm reluctant to say anything critical of colleagues in any agency when I just don't know the underlying situation and it isn't something within our authority. I can say that EPA in the rulemaking domain has been extremely careful and scrupulous about ensuring that there's public comment before it goes forward with rules. And we had an earlier colloquy about the EPA's insistence that
But wouldn't you agree with me that when the Army Corps of Engineers signs off on it and says everything is fine, and then some 18 months to 2 years later the EPA comes in and yanks the licenses out, that does not promote predictability and does promote uncertainty?
I need to know more about the particulars. I certainly agree with your emphasis on predictability and certainty, which are up front in the new executive order.
And wouldn't you agree that at least on the face of it that such action is not plain and easy to understand?
Well, I'm very concerned about clarity. The Plain Writing Act is something that is within our domain. We recently issued guidance on it. But I've learned from my period in Washington that things that are on the face a certain way sometimes aren't fully a certain way. And so if you'll forgive me, I'd like to be cautious before speaking on that.
Well, I understand being cautious, but you can appreciate that the uncertainty that has now been created in the entire region about even attempting to invest money in opening up a new mine that has been caused by the actions that were taken. And isn't that something that under the executive order that you all should be looking at?
The administration as a whole is committed to promoting certainty. So to look at something that is raising concerns along that front is completely appropriate.
All right. I thank the gentleman.
Thank you, gentlemen. Now recognize the gentlelady, Ms. DeGette.
Thank you very much, Mr. Chairman. Mr. Sunstein, I really want to thank you for coming and testifying today. I found your testimony very illuminating and helpful, and I think this subcommittee is going to want to have ongoing conversations with you. You know, we all agree that unnecessary regulations should be repealed, and new regulations should not be overly burdensome on business or anybody else. I mean, that's the fundamental. Listening to the questioning on the other side of the aisle today, I kind of realized that there's this assumption that may have some vague historic basis, but certainly with this new administration and with my colleagues on the Democratic side of the aisle, we don't believe in overregulation, and we don't believe that regulation should be burdensome. Especially right now with unemployment still over 9%, we need to make sure that regulations are sensible, that they protect the public health and well-being, and are not overly burdensome. I was particularly interested, and I think so there's some thinking, since there's a Democratic administration, we're just over-regulating. But in fact, when you look at the actual facts and statistics, this is not the case. I was particularly interested in your comment earlier that the total number of rules in the first 2 years of the Obama administration is comparable to the number of rules in the last 2 years of the Bush administration. So about the same. And if you look at the numbers for the EPA specifically, which seems to be a great concern on the other side of the aisle, the comparison between the administrations is very noteworthy. The EPA has finalized or proposed fewer Clean Air Act rules over the last 21 months than in the first 2 years of either President George W. Bush's administration or President Clinton's administration. President Bush finalized or proposed 146 Clean Air Act rules while President Clinton issued only 115, and President Obama has issued just 87. And frankly, some of the Obama administration's rules, as you can attest, are trying to clean up the mess left by the previous administration. So let me give an example of that. A federal court threw out President Bush's rule to cut toxic mercury emissions from power plants in February 2008 because, frankly, it was illegal under statute. So what it would have done have been to left infants and children vulnerable to mercury pollution. So President Obama and his administration were then forced to go back to the drawing board and repromulgate those rules because they were illegal the first time. And so frankly, I think that, Mr. Stearns and I are both eager to talk about regulations that might be burdensome, and we're eager to work with you and the administration to do that. We were just saying that we would welcome suggestions by members on both sides of the aisle, and then we'd love to sit down and meet with you and your staff to propose anything that we think is overly burdensome, because frankly, we're not facing a regulatory avalanche. These are safeguards for the American public, but I know that you and your staff intend to promulgate them in a way that is the least burdensome possible. So I just wanted to say that. And Mr. Chairman, I just wanted to ask the majority a question, and maybe you know the answer, but if not, maybe your staff or somebody else can tell me. The Republicans have said, several of the folks on your side of the aisle have said that an EPA spokesman said that the executive order won't matter with respect to the EPA regulations. And I don't know who that spoke. We're unaware of any statement like that on this side of the aisle, and I'm wondering if your staff or the members who said that could tell us who that spokesperson was so we could set the administration straight that the executive order is going to apply to all regulations of agencies within the purview of Mr. Sunstein and his staff.
We'd be glad to provide it for you. It's in the Hill.
Thank you.
January
what is the name
18th. Facida Alcantara. In the statement said the agency has already been following many of the protocols formalized Tuesday, and so we'd be glad to give the Hill article to you.
Wait a minute. This doesn't say that the executive order doesn't apply to EPA regulations. And Mr. Chairman, I would ask unanimous consent to submit this article for the record.
Oh, sure. Be glad to by unanimous
Thank
consent.
you.
But I think we've given you a name. It's your interpretation.
Yeah,
of
you
it.
did, but it doesn't say anything
Well,
about the
that's
executive
your
order and whether it applies.
That's your interpretation, our interpretation.
May I make one brief addition to your
Sure.
excellent remarks, which is if you look at the most expensive fiscal year of the last ones, it hasn't been 2010, it hasn't been 2009, it was 2007.
Okay. Gentlelady's time has expired? Okay. Let me close. Mr. Sunstein, thank you for your patience, forbearance while we voted. Let me just ask you sort of a question to clarify what Ms. DeGette was talking about. In the first 2 years of the Bush administration, how many regulations were issued compared to the first 2 years of the Obama administration?
We'll have to get that number.
Okay, that's important because I think what she's alluding to, I think those facts are now apples and apples instead of apples and oranges. Let me also point out that when Ms. DeGette talks about deregulation, on this committee we had a cap and trade bill we passed, which the Senate didn't agree with. We had a health care bill passed. The Congress under the Democrats' majority had a financial bill. They also had bailouts, and so during all that process, when you pass those four major pieces of legislation, you're going to have more regulation, no doubt about it, which goes to the heart, which I'd like to conclude with. You had indicated that there should be a comment period for the citizens of this country to tell you and OMB that these regulations are killing us, and you're saying you're willing to listen. So can I suggest that we sit down with you and we notify our members, both on the Democrat and Republican side, that you have made this very auspicious, generous offer to take seriously some of the problems. Now, the gentleman from West Virginia pointed out that this company has lost its license after getting approved by EPA, and, you know, that's that's a problem. That's losing jobs. That's exactly what I think the President's talking about. So can we have your agreement then today that you would sit down with this committee at a later date, not in a hearing, but in an opportunity where Mr. Gett and I could present you of regulations that we think indeed are hurting this country and should be repealed? Is that
I would welcome that.
Okay. Well, I think you'd suggested the idea, so we just want to follow up on it and make it. Okay. Let me conclude by saying members have 10 days to submit questions for the record. And if there's no further comment, the subcommittee is adjourned. And thank you.